of this committee here at M46 and on the virtual, to also acknowledge the public protector here at M46, as well as a legal team led by Advocate Mpofu, also here at M46. You are recognized. I recognize the evidence leaders, Advocates Bauer and Advocate Mayosi. I recognize members of the media joining us, the entire support staff of the inquiry. Last but not least, the important people of this inquiry and in this country, those who have sent us to be here, members of the public, and your various platforms. Let me welcome you on this important day, an important month. October is a month of legends. And one of those legends is a true Democrat, a constitutionalist, who dedicated his life to us being here. Judge Albie Sachs, in his book titled Oliver's Dream, says his DNA can be found from the first page to the last page of our Constitution, because today is the birth of that South African, Kaizana Reginald Tambo. I acknowledge. I also acknowledge even those who would not have been October legends. I'm told that Advocate Mpofu would have reached a milestone somewhere in September, but not in October, a 60th milestone. I recognize that. Thank you, Chairperson. Thank you. We have no apologies and would therefore proceed. I will just quickly set the scene with my introductory remarks and then outline, as would have been outlined in the agenda, the proceedings of the day today as we resume our work. The public protector had indicated via correspondence sent to me that she intended to challenge the failed recusal application in court by way of review proceedings, and requested that these hearings be adjourned pending the outcome of that review. I responded acknowledging her request and advising that such an application be made in writing. This is the application that the members would have received and studied. I further indicated that I will give Advocate Mpofu and the PP's legal team the opportunity to make oral submissions on the application this morning. I had indicated to the PP's team that I will allow them an hour to make oral submissions on the adjournment application, a time frame that I was comfortable would be fair. I did, however, indicate that I would reconsider at the start of this meeting whether, in the light of the length of the written application, additional time should be granted. I've therefore decided to grant an additional 30 minutes, allowing an hour and 30 minutes to make oral submissions, after which I will allow the evidence leaders to make any comments, if any, and then opening the floor for members to seek clarity, questions only at that point. Thereafter, I will ask Advocate Mpofu and the evidence leaders to excuse themselves to allow us to deliberate and reach a decision. Unlike in the past, where I determined requests for short delays and minor amendments to the program, as is within my powers to do so, as a chair. This application is somewhat different in nature, in that it seeks to adjourn the proceedings and in essence postpone the entire inquiry to some unspecified future date, which would depend on litigation still to ensue. I intend to allow the committee as a whole to deliberate on it and reach a collective decision. I will await Advocate Mpofu's oral submissions before making up my mind on the matter, which I will shed further light on the issues. It is only once the fate of this application is decided, depending on the outcome, which will be one, either the inquiry adjourns with further hearings to be held at some future date, or two, in the event that the committee is not minded to grant the request to stay the inquiry pending High Court application to be brought, you would have seen from the correspondence that I had informed the PP's team that in the event of the latter, that the committee would immediately continue with either the cross-examination of Ms. Thejane, which is an outstanding matter, or Advocate Bauer will lead evidence of Mr. Niels van der Merwe. However, we will cross that bridge if and only if we get there, but I mention it so members are aware that the hearings may continue today. And therefore, on that note, honorable members, allow me to recognize and invite Advocate Mpofu to address the committee. Over to you, Advocate Mpofu.
Good morning, Chairperson. Good morning, everyone, honorable members, colleagues. Yes, Chairperson, thank you very much for the birthday wishes. Just want to tell you two things, that 60 is the new 30. And
you what?
New 30.
Okay.
Yes.
Okay.
And also I take exception to you saying you recognize me under the category of not legends. One day I will be a legend. But thank you, Chairperson. On a more serious note, Chair, I will, let me just, because there's not so much time, I will get right into the written submissions. It's 10:10 now. Chair, I know you've given some of the background, but I think it's just to situate what my address. Indeed, as you have said, this is an application for an adjournment or postponement. It really means the same thing, of the proceedings pending a review application, which we have formally informed the committee to be instituted very soon, as you indicated, Chair. And let me point out that one of the reasons why those proceedings have not been instituted is exactly what we are busy with today, because whatever happens today will form part of those court papers. So I can say those papers are probably about 60% ready. But so the other 40% is in your hands, Chair. And that's quite a serious matter, because depending on the outcome, you'll be hearing those words from me many times today. Depending on the outcome of today, all sorts of permutations. When we come to what I call the practical arrangements, then we'll map out whatever scenarios, whether we're going to go to court once or twice or whatever. It all depends on the outcome of today. So today is quite important. Chair, the second thing is, and I want to say this up front so that there's no confusion. In the letter that we wrote to you about this about today, we made it clear that at paragraph 5 of the letter that we wrote to you dated 21st October 2022, and again, we appreciate the fact that you gave us time to come this week. And we said that even when we attend here, it will be our intention to attend for the purposes of making an application for the adjournment of the inquiry pending the envisaged court challenge. Depending on the outcome of that application, notice of which is hereby duly given, we would be available to make realistic and practical arrangements of the way forward at that stage. So for now, our mandate is to move this application, and depending on the outcome, we will then deal with the way forward. Chairperson, I think the most practical way to do this is to try and follow the written submissions, and then I'll just speak to them on the assumption that the members have had time to gloss over, even if they haven't read it in detail, but at least to understand the parameters of the application. Chair, just to do some typos on the first page, there's that preamble there. It says an authority should halt its actions when it is aware the review. It should be that when it is aware that review proceedings. Okay. And then the next one is your error, Chair, which I'll take the opportunity to correct. On paragraph 5, where we quote your letter, you say, in this application, kindly indicate by what date you intend to launch such recusal application. You obviously wanted to say review application. So I think it was just a slip of the pen. And then at page 5, heading C, it says illustrate case law. It should be illustrative case law. Illustrative, yeah. Okay, if we pick up anything else, we'll correct those. But those are the ones I could pick up quickly, Chair. Right. Now, if we can then please go to the very preamble that I referred to now. I'll be coming back to this theme very often. What we're busy with here, Chairperson, is not a small thing. In our law, it has been said that the issue of administrative rights, administrative justice, let me put it that way, is quite serious. That's why we have the Promotion of Administrative Justice Act, otherwise colloquially known as PAJA, which is what really governs things like this. So although Parliament is part of the legislature, when it performs functions such as this one, which in the old days we used to call quasi-judicial, then it is susceptible to the Promotion of Administrative Justice Act. And so the review that we're going to launch is primarily premised on that act, but also on the principle of legality. But that's for another day. I'm saying that to explain the importance of review proceedings in the larger scheme of things. Now, the question becomes, and this is going to be the central question when you adjourn, Chair, which is, we can, as normally happens, we can do this the hard way or we can do it the easy way. The hard way would be, as I say, what I'm going to tell you, all the legalities. But we have, as you would have seen by reading this, we've also proposed that we could also do it by way of an arrangement. That arrangement would involve probably myself, yourself, the evidence leaders being locked up in some room for an hour or so and being told that you can't come out before you have a practical way forward. Because it's not an easy thing, Chair. We appreciate the fact that it's a balancing act. On the one hand, the inquiry has to proceed and nobody wants it to proceed more than the public protector. On the other hand, we live in a constitutional democracy, so people's rights have to be protected. It's not an easy thing always to balance those. And even for the courts, it's not an easy thing. So it's always better if there's a way in which it can be negotiated, that it should be. But if we can put back that preamble. This comes from the case of Piccoli versus the president, well-known case about the suspension of a NDPP. And this is the quotation that I really want to be at the back of everybody's mind when I say anything that I'm going to say. It says, in appropriate circumstances, an authority, that would mean this committee, should halt its actions, that would mean the inquiry, when it is aware that review proceedings are to be instituted against it. Failure to do so may render the official, that means the committee, the official concerned liable for contempt of court. Let me unpack that very briefly. You'll see that that's exactly where we are, Chairperson. It says proceedings to be instituted. In other words, the mere fact that the proceedings have not yet been instituted now is not relevant, as long as you correctly pointed out, the committee has been made aware formally that such proceedings are to be instituted. And the reason for this, for other people, is that it's to protect the integrity of the constitutional democracy. And contempt of court is a criminal offense. So always something that is punishable by a criminal offense just shows how seriously the law takes it. So if the law if you continue with your inquiry when you are aware that proceedings are to be instituted, you may render yourselves guilty of contempt of court in appropriate circumstances. And that will be the question that I'm going to address now, whether these are indeed appropriate circumstances. Chair, the first 2 pages are just the background, which you've already mapped out, so I'll jump that. And I'll go to paragraph 9, where just to re-emphasize what I said earlier, it's important to state it clearly and upfront that in bringing this application before this committee as presently composed, the public protector does not thereby abandon or in any way waive her right to forcefully argue that the committee is not entitled to sit at all once it has been made aware of her intention to challenge its composition and jurisdiction in the envisaged judicial proceedings. To paraphrase that part, Chair, is to say, you remember, I think it was Honorable Zungula who raised the issue whether you could chair the previous sitting on recusal. And I think Advocate Bauer and I explained to him that you were the only person who could chair that. The point we make here is that once you've made the decision on recusal, then that dispensation basically expires. And so for practical purposes, if the tribunal is being questioned, that should be, basically you would then be conflicted because you'd be chairing on the issue about your own alleged conflict. But there's no other way to do it. There's no other place where we can bring this application. And therefore, to that extent only, we are here. But we say this so that later we're not accused of having waived our right to object to the committee. So that dispensation will end, as far as we're concerned, once the outcome of the application has been determined, because we have to, I think from a practical point of view, we have to give the committee as currently constituted or wrongly constituted the chance to do the right thing. So we say her participation is therefore not acquiescence in the legal capacity of the committee to proceed with any other business, which capacity is hereby specifically disputed. That's at paragraph 11. Now, if you go to paragraph 12, Chair, we say that, because you asked us specifically to postulate when the application might be ready. We have said 31st October, which is Monday, but I want immediately to qualify that. That also depends on what happens, whether the outcome of this application. But we have every intention, at least, to do it. Not if it's later than that day, it will be a day or two because of just the practicalities of drafting and some engagements for the weekend and all that. But I think the principle is the same, Chair, which is that it will be done expeditiously. Obviously, if the decision, I think let's just work on the principle. So the principle is that if you make the decision today, then it might be 3 days afterwards, it will be ready. If you make the decision at another time, it will be soon thereafter. So I'm just qualifying that so that you don't put a neck on my neck on the block to say it's the 31st or past. Yeah, it's a target. All right. And then we say that depending on the outcome, we'll seek an order declaring in the application itself now the decision of the majority of this committee to refuse to adjourn the proceedings to be also unlawful. By that we mean that when the application comes, one of the prayers in that application, if you dismiss the application today, as we think you will be to set aside not just the non-recusal decision, but also the non-postponement decision. I'm just using those as, and we say there that although that decision has not been made, I mean, we anticipate, I think we've been here long enough to anticipate what the decision is likely to be. And we're saying that then if it's different, then that prayer in the review application will simply not be pursued. In other words,
and when you say you think that we will take that particular decision, what are you basing that on?
It's, as we say, the paragraph 15, based on past experience. We said it makes it easy to predict. We can be wrong, but at least, if we're honest, it's from past experience. It will be easy for us to predict what's likely to happen, given what we used to call in the 80s the balance of forces.
So when you have a possibility of two assumptions available, you prefer to stay on this one?
No, Chair, I'm not discounting that there are two. I'm saying that in life, you from past experience, if the sun comes from the east, so one day it might come from the west, yeah. But normally you can predict certain things. Yeah. I'm just saying that given the fact that people vote according to party lines and according to whatever the issue is, I think even a 2-year-old child can just do a head count and tell us what's likely to happen. But we're not there yet, Chair. The third point then that we make is that the relief we will seek in the review application will be substitution. Now, again, I'll simplify that. So when you review, you either say the court must remit, in other words, it can take it back to the decision maker, or the court must make the decision itself. Now, in a case where there's bias alleged, I won't put it higher than that. There's no point in taking it back to the decision maker who's already biased. That's illogical. So that's when you ask the court to make the decision itself.
You mean a decision maker who is alleged to be biased?
Yes, Chair.
And not biased.
Yeah.
just so that we're in the same lane.
Thank you, Chair. No, Chair, you really, if you play the record, you'll hear that I said alleged bias. So I agree. The point is that it would be illogical if it's a fait accompli, as the lawyers like to say, then the court will give a substitution. If it was just an inadvertent error of some sort, then obviously the decision maker can do it again. And that's because of a higher principle. The courts normally don't like to, because of separation of powers, to make a decision for other arms of the state. So the default position is to remit, but under certain circumstances, you substitute. And then the last point, which is important, is number 17 on this, the nature of the application we're going to bring. And that is that the application is premised on the notion that it would be gravely unjust to expect the public protector, pending her court challenge to the composition and unfairness of this very committee, to be subjected to an inquiry before the very same committee. In the event that she succeeds in court, the entire exercise would have been futile and wasteful. Let me just pause there, Chair. This is another poser, if you like. The issue, it's a difficult one to balance as well. There's a school of thought that says, look, you might feel that the person is biased or a judge is biased and so on. But for the sake of progress, wait until the end and then raise it at that point or until the outcome. The reverse, which is favored by the court, is that no, you mustn't wait until the end. You must raise your objections as soon as you are able to do that, because what would be the point of wasting more resources on something and then later? And also it makes it susceptible to the accusation that, oh, in fact, it happened in one of the cases that I'm going to refer you to, where the lawyers actually said, no, we knew about this. It was about a judge who had shares in a company. So no, we knew about this, but we thought we'll wait until the outcome before we raise it, because if we win, then it's okay. And then the Constitutional Court said, no, you can't do that. You can't say you're going to wait for the outcome, and only when the outcome doesn't favor you, you raise the issue. But this is more important for you as lawmakers, Chairperson, because you are the people who oversee wasteful expenditure and those kinds of things. So it would be said if the Parliament itself would be promoting going through a wasteful exercise, which might be nullified by the court, because it would just be completely a wasteful exercise to do that. And that's why it's the courts encourage you to bring it as soon as possible, so that we don't waste resources, particularly in a process like this. So we then say, Chair, that without, because the last thing we want to do is to come here and then re-argue the recusal application. That's been done and it's been determined. But so we refer to the recusal application only to show that the review application has got prospects of success. And that's why we don't go through all the 12 things. We just pick 2 or 3 that we think are quite obvious. Because I think it would be fair, Chair, to say one of the things the committee has to consider when you consider your decision will be that issue of I mean, if you thought this review application is just hopeless completely, that's a factor you must consider. But if you think that it may succeed, then you consider that against the wasteful exercise that might ensue thereafter. So we only raise it for that purpose. Please, nobody must accuse us of re-arguing the recusal application through the back door. That's not our intention. Okay, the issue of prejudice is obvious that the public protector, well, everybody, the public and the public protector and the fiscus would be prejudiced if we just go through an exercise for the sake of it. Chair, before I get to the illustrative case law, let me just put something to bed. Many people here have been saying that this is not a court of law. Even you in your reasons, it's not a court of law. I'm not a judge, which is all true. But let me assure you that when it comes to what we're debating now, which is the issue of bias and administrative justice, there is no difference whatsoever. Whether you're a judge or whatever, the justice is justice, fairness is fairness, bias is bias. There might be different standards that get applied. If you're a judge, for example, there's something called the presumption of impartiality. So when you want to recuse a judge, you have to first overcome that presumption of impartiality. Unfortunately, you are not a beneficiary of that, you and many other administrators. Yeah. But other than that small difference, the test is exactly the same. And so that's the first, that's very important, Chair. The second important, no, let me just refer you to that. If one of the, I don't know if the cases were sent through. I sent through some of the cases that we're going to refer to, just so that members can have access to them. I think they were loaded yesterday. Tim goes. You got them? Okay. Okay, you don't have to put it up. I just wanted to know that members have got access to it. Yeah. So the first case, okay, it's not the first case I wanted to refer to, but I'll refer to it now in this context. It's the case of Basson. I'll talk about it later, but I just want to make this point. In Basson, the following was said, Chairperson, at paragraph 25. And this was quoting a constitutional court decision. It says that a cornerstone of any fair and just legal system is the impartial adjudication of disputes which come before the courts and other tribunals, such as this one. Nothing is more likely to impair confidence in such proceedings, whether on the part of litigants or the general public, than actual bias or the appearance of bias in the official or officials who have the power to adjudicate on disputes. And here's the important part of the point I was making. The rule against bias is thus firmly anchored to public confidence in the legal system and extends to non-judicial decision makers such as tribunals. And the rule reflects the fundamental principle of our constitution that courts and tribunals must not only be independent and impartial, but must be seen to be such. And the requirement of impartiality is also implicit, if not explicit, in section 34 of the Constitution. Paraphrased, what that two takeaways from that. One is that the rule applies equally to whether it's a court or not a court is completely irrelevant. Secondly, that it's rooted in section 34 of the Constitution. As we all know, at least in this room, section 34 of the Constitution specifically also says that. It says you have a right to have your dispute decided in a fair process in a court of law or any other tribunal which is constituted in terms of the law. So that's a crucial, those are crucial issues. So this refrain that no, this is not a court of law and so on, in respect of what we're discussing, is completely, I hope nobody is going to go there, yeah, because as I say, fairness is fairness, bias is bias. And in any event, your own rules for this committee, Rule 129A(d)(2, enjoins you to follow a fair process. So what we've then done, Chair, to illustrate the principles, and this is really now what I call the meat of what we want to talk about, is to show, again, this is for two purposes, Chairperson. One is to show you what the law says on this, but at the back of the mind, also keep the fact that we're also talking about prospects of success, because I believe, in fairness, that it is a crucial consideration that you must have. So in other words, I'm showing you what the law is, but I'm also saying in a way that the review is going to succeed. And why I'm saying it's going to succeed, because every principle, every court in this country has said that a review of this nature, its chances of not succeeding are probably less than zero. And therefore you'll remember that there were those 12 grounds that we spoke about. So some of what I'm going to say will touch on some of those grounds, just as illustration again. Doesn't mean we abandon the other grounds. So of the 12 grounds that referred to you, Chairperson, and then the 2 grounds that referred to Mr. Mileham, we will use them for this illustrative purpose, just to show that on the cases, it's a slam dunk type of case. And we deliberately, Chairperson, for that purpose, want to take you through every conceivable court you can think of. So we show you the high courts, what the high courts have said on this. We'll then show you what the SCA has said on this. We'll then show you what the Constitutional Court has said in this, and we'll even show you an example of an international case, which have all said the same thing. So the chances of ever, remember, if we take this review, we'll be taking it to the High Court first. So the High Court is bound by whatever has said. It has no choice. And what the Constitutional Court has said. And what the international courts have said will be persuasive, but not binding. So if we are correct that all those levels of courts have said basically the same thing, then, as I say, the chances, yeah, would be miraculous. So let's start with the high courts. Now, as far as the high courts are concerned, we refer you firstly to a case that the committee will be familiar with, which is the case of the public protector versus yourselves and the president, where the presence of bias on the part of the president was seen as a ground enough to set aside his decision to suspend the public protector. That should illustrate to anybody who cares to know that the courts will punish, quote unquote, bias by setting aside a decision which is tainted thereby. In that case of the president, it was worse because there was also dishonesty, bias, ulterior motives, bad faith, or corruption from the highest office in the land, in the sense that the action was taken for self-serving personal purposes of escaping an investigation. Now, we say at paragraph 22, Chair, that the dictum or the statement made in Piccoli, that's the one in the preamble, is then is also a High Court decision. So the thing that says that it will be contempt of court to continue in circumstances where you are aware that there's a review application is also a decision of our High Court. So whatever court will hear this will also be aware of that as to when it looks at your decision. Assume for now that my prediction is correct. When it looks at your decision to refuse to postpone the matter, the court will then be guided by those decisions of itself. But, and I can't emphasize this more, Chair, the second case that we deal with is the case of Basson. Basson, everyone will remember, this is the Basson, voter Basson, the Dr. Death, I think that's what he was called, the gentleman who used to work for the apartheid regime and poison our leaders under the guise of being a doctor, pretending to be a doctor. So even subhuman people like that, unfortunately, have to benefit from the law. So he was protected by our courts, disgusting as some might find his conduct. And we make that point at paragraph 23. We say, even somebody so objectionable and cruel must enjoy the full protections afforded by our Constitution, let alone a public protector whose only sin is seemingly her enthusiasm for chasing backlogs, ensuring service delivery to the poor, and investigating alleged presidential misconduct. So we're saying, even though she might have been pursuing those noble causes, and Basson was pursuing vile causes, the very least she could expect is the same type of justice. Now, what happened there in a nutshell, Chair, without wasting time, is that Basson then had to be removed from the role of medical practitioners because of those dastardly acts that he was involved in. So the HPSC, which is the Health Professionals Council of South Africa, then set up a committee, much like your committee, Chairperson, to investigate, inquire into the conduct of Dr. Death. And he raised an issue, an interesting issue, much like the issue that has been raised against you and Mr. Mileham. He said, look, I know you want to remove me from being a doctor, but two of the people sitting in your committee, one are members of one of the bodies that have complained or that have supported the case. And therefore, they are biased, automatically biased. And so I can't continue with this. Now, there were two interesting things that were raised in that case. One was that something which is not directly relevant to this case about internal remedies. So the court said in these kinds of circumstances, he's even exempted from exhausting internal remedies, which is normally the requirement in administrative reviews. Because how could he be expected to exhaust internal remedies which involve the same biased chain of events, so to speak, including even the appeal process in that case. But the most relevant thing to this case is that the court then said that it dealt with the issue that we're busy with today, which is that you can't then expect that very committee that he says is biased to be the one that's going to proceed with the inquiry. That is just nonsensical, if you excuse the language, for the reasons that I've explained earlier. And this is what Justice Shongwe, who was the acting president of the SCA, said in that matter. If a presiding officer, now bear in mind that I've said there's no distinction, doesn't matter whether it's a judge or you or the committee or whatever. So whenever I say presiding officer, you must just substitute the committee or the chairperson. If a presiding officer should have recused himself, proceedings conducted after the dismissal of an application for recusal must be regarded as never having taken place at all. I have to read that again. If a presiding officer should have recused himself, proceedings conducted after the dismissal of an application for recusal must be regarded as never having taken place at all. In other words, it's just a complete waste of time and money. And then it says here, in the instant case, the appellant's complaint was not that the finding of the committee is an irregularity committed by an otherwise competent tribunal. Instead, his complaint was that the committee lacked competence from the outset because of the actual or reasonable apprehension of bias on the part of two of its members. Stated differently, the appellant alleged that by virtue of its composition, the committee could not exercise jurisdiction over him. So this is not a case where the committee wrongly acted within its jurisdiction. The appellant alleged that it has no jurisdiction from the start. The issue is one of elementary justice. Again, one doesn't have to be a lawyer to understand this. What is being said there is that it's the point that was made by Honorable Zungula with respect to him prematurely at that stage here. And it is that what we are saying here is that the committee as currently constituted has no jurisdiction to do this until the problem has been resolved, and therefore you can't then expect the litigant or the person who's facing the committee to just continue. And that's really, in a nutshell, what we're here for, to say either you're going to say, no, we're just going to forge ahead, even if whatever we're doing is going to be regarded as never having taken place. We'll just do it as Lemesieke, irrespective of the obvious consequences. Or you'll do the right thing and say, let's let the justice system take its course, and we will await, or we'll make sure that it doesn't take too long, and we'll negotiate a regime. And that would involve all sorts of things, like jointly approaching the judge president to say, let it be done as soon as possible, and so on and so on. But if you don't enter into those kinds of discussion, then it's open season. It can take as long as it takes, because we don't know, we don't control the court rules and so on. So the SCA has made it clear. Then Chairperson, and I've already read out the other part from Basson. Then the big one, the Constitutional Court. Constitutional Court has also weighed in on these matters. And it has also made it clear, Chief Justice Ngobo, as he then was, in the famous case of Bennett versus Absa Bank, which is a Constitutional Court case. And Chair, again, I don't want to bore you much with the facts, but I'll just give you 2 or 3 highlights. In this case, the case had gone to the SCA. In the SCA, one of the judges, Judge Kachalia, disclosed that he was a shareholder in Absa. And it was Bennett versus Absa, so in one of the parties, among other things. It's got very interesting facts. It's the case I was telling you about, where the lawyer was told, the disclosure was made in chambers, but the lawyer said, I didn't tell the client because I told you, I wanted to await the outcome. Yeah. And the court said, you shouldn't do that. Anyway, the court, one of the things the court said about the test, which is really why I'm citing this case, you'll find on page 8, of our document, and I want to read it out in full because this one is crucial, because the Constitutional Court here, in a way, covered both the recusal against yourself, Chairperson, as well as the recusal against Mr. Mileham, and I said to some extent, the recusal of the, not the recusal, the alleged bias of the committee. Remember, I'm just pausing here. Now, the application we're bringing now, Chair, is much more serious than even the recusal application itself, because the recusal application was against yourself and Mr. Mileham. This application is now covers yourself, your non-recusal decision, Mr. Mileham's non-recusal decision, but crucially, it covers the committee's decision to endorse those 2 decisions. So it really covers everyone else. So it's a much more serious issue. So when we talk about contempt of court, in this case, it won't be contempt of court by yourself or Mr. Mileham, it will be by the entire committee to proceed under these circumstances. Actually, ironically, it won't be contempt of court against you and Mr. Mileham, because you wouldn't have decided to proceed in the face of a review application. It will only be the committee that will have decided that. So you'll only be co-accused in what we used to call common purpose, like everyone else. You won't have any special liability. All right. And the only people who might be safe are those who would have not been part of that contempt of court. So this is what Ngobosi J said, quote, "It is by now axiomatic that a judicial officer who sits on a case in which he should not be sitting, because seen objectively, the judicial officer, that's the committee, is either actually biased or there exists a reasonable apprehension that the judicial officer might be biased, acts in a manner that is inconsistent with the Constitution." I mean, that this should be obvious to anybody, with a few exceptions. This case concerns the apprehension of bias. The apprehension of bias may arise either from the association or interest. Let me pause there. This is the Mr. Mileham situation. It may arise either from an association or interest that the judicial officer has in one of the litigants before the court, or from the interest that the judicial officer in the outcome of the case has in the outcome of the case. Why do I say that this involves Mr. Mileham's situation? Because the interest in one of the litigants means this in the context of this case. And one always runs the risk of making an example that will be taken literally, but it's a risk I'm willing to take. Yeah. It depends on, yeah. So Chair, we say there are charges. We all know that when we say charges, we don't mean it's like a criminal case, yeah. But we use that word. So let's take it from there. So you have charges, and then you have complainant, then you have an accused. All those terms are not exactly appropriate, but I'm just using them to illustrate. So the complainant in this case is Ms. Mazzoni, MP. The accused, quote unquote, is the public protector, and the charges is the motion. Okay, so that's what is meant here. So if you have any interest or conflict relating to one of the parties, that's it. It's what is called automatic disqualification. And I'll show you later that in the international case of Pinochet, it is said that that kind of conflict, actually, you don't even have to go to these issues of reasonable apprehension of bias and what have you. Automatically, you're out. the same as that judge. So if the judge had shares, you're out. English law is very clear on that. I gave you an example, I think earlier, when I was doing the recusal application of a case that I did last year, where the judge correctly, as he should, disclose to us as the parties and said, listen, I have shares in Sibanye. It was the matter of the Marikana workers suing Mr. Ramaphosa and Sibanye, and the judge rightfully disclosed to us, which is one of the problems here because there's no disclosure, and I'll explain that later. And then the judge said to us, look, do whatever you want. So I obviously went to my clients and I said, the judge has disclosed that here's these shares. What must happen? I know the judge, it was Judge Colin Lamont. Personally, I had no problem with him sitting in the case, but it's not my case. So then the client said, no ways, we can't have a judge who's got shares in the defendant. You must apply for his recusal. Always the most difficult thing for any lawyer. Once the client says that, your heart sinks, because fortunately, I've only done this 3 times in my entire life. Anyway, so we did the application. The judge said, which is very crucial, Chairperson, like you and Mr. Milham, the judge said, look, I have these shares, but I'm going to do this matter objectively. And I know him, as I say, it's someone I know from the bar when he was still an advocate. So I had no reason to disbelieve him when he said he's going to do it fairly. And yet he recused himself because he said, applying this principle, it doesn't matter that I'm objective. It doesn't matter that I'm going to decide this matter objectively. But from the reasonable litigant's point of view, I can't sit in this matter. And he recused himself. Then the matter was only had 6 months ago before another judge. And that's one of the fundamental problems with what was happening here a couple of weeks ago. I watched it on TV because the committee was swayed by the chairperson or Mr. Milham saying, oh, I'm fine. I have no predisposition or predetermined outcome, but that's utterly irrelevant. The test is whether a person in the position of the public protector reasonably expects somebody who is the husband of the complainant to be objective. Anybody who expects her to reasonably believe that is out of their minds, because that's just not something that you can reasonably expect anyone. She might, and the disclosure point is very important, because let's assume, Chair, the right thing had been done. If Mr. Milham had said, for example, when we start, public protector, I want you to know that I have this potential conflict. Public protector could have said, like I would have said in the other case, it's fine. Let's just carry on with the inquiry. In that case, then you waive your right. That's why disclosure is important. Non-disclosure is also a big no-no, because once you don't disclose, is either you're hiding something, or even if you're not hiding something, you are at least depriving the other side of the chance to say you can carry on. So that one, both the relationship and the non-disclosure are fatal in a case of this kind. So that's what they say there. And say, or it may arise from conduct. This is now you, Chairperson, and Mr. Milham, by the way. Yeah. Or it may arise from the conduct or utterances by a judicial officer prior to or during proceedings. Now, this is important for you, Chairperson. They say the bias may arise from utterances that are made by a judicial officer. Now, the legal experts who I learned from the discussions I watched on TV are said to be advisors of the DA or representing the DA, but that's a separate matter raised by the MPs, which at this stage. We will raise it in the review papers, to be fair, but I'm not raising it now. But I'm just saying, so the fact that those so-called legal experts or independent experts were not independent is a matter that will be dealt with by the review committee. Now I'm only dealing with the fact that they were wrong, even if let's assume they were independent. They were just wrong. Because one of the things they say in their opinion is that, no, it doesn't matter what the chairperson said. The fact that the chairperson said that the public protector is incompetent, because they say there are two reasons they give. One is that he said it 2 years before the inquiry, which is factually untrue, but let's assume it's true for now. Then secondly, they say the chairperson took an oath of office. Now, both of those are actual like non-reasons. The first one is that whether you say 2 years or 5 years or 10 years or whatever, it doesn't matter. The point is that if you've made those utterances, you've made them. So that's why the Chief Justice said, or it may arise from conduct or utterances by a judicial officer prior to or during the proceedings. So the mere fact that they were said prior to doesn't make them acceptable. And then the second one about the oath of office is just laughable, because judges who have taken an oath of office get recused, as I've explained before. So why should a member of parliament not be recused just because they took an oath of office? And that's just, but anyway. So, and then it says the apprehension of bias principle reflects fundamental principle of our constitution that courts must be independent and impartial, including tribunals. And fundamental to our judicial system is that courts must not only be independent and impartial, but they must be seen to be independent and impartial. Crucial rider. Then, Chair, if I may, let me just jump to the Pinochet case. If you allow me. No, let me follow the sequence. I'll come to the Pinochet case, which is the fourth case, yeah, because it's also important. Let me just deal with the prospects of success. I've already dealt with them, as I indicated, Chair. So we say that the purpose of the section is merely to demonstrate by using these few examples that the public protector's case on review is virtually unanswerable, and therefore it has excellent prospects of success on review. Okay, then we deal the thing about the oath of office I've already dealt with. The thing about utterances made prior to, I mean, it's just, yes. Then we talk about the events of the 13th of September, Chair. We say the explanations given for this tribunal here to continue in the absence of the public protector who was sick at the time is I mean, to take, I don't know how long it would take me to just show you that all of them are completely cannot withstand scrutiny. It should be obvious that you cannot proceed. And even in terms of Paja says one of the things that must happen is that when you are being tried or subjected to any process, disciplinary or otherwise, by a tribunal, one of the rights you have is the right to be present. And that's what we try to explain ad nauseum to this committee, that you can't do this. Even a serial rapist who goes to court, when they are sick, the case is postponed. I mean, you know, why? Not because people like the serial rapist, but because he has a right to be present. You can't be tried in your absence for something which might result in so much jeopardy to yourself. It's not done. Okay. So There's no way to explain such a thing, let alone the breaching of the directives by allowing members to ask questions before cross-examination. Then you breach your own directive. I mean, put that aside. Just the idea of uttering even one word when the person is sick and say, let's just carry on. Let them eat cake, as it were. The refrain was not let them eat cake. It was, she'll watch it on TV or something. It's not done. All right. Okay. So there are certain things in, ironically, one of the cases that you say you are bound by, which is the case of the public protector versus South African Reserve Bank, established that principle that sometimes if you just by disallowing somebody of their Audi rights, that disallowance may be so gross as to only be explained by bias. That's what Khampepe J said against the public protector in that case. So it applies here as well. When something is so blatantly, the denial of rights is so blatant that there's no other explanation for it except bias. In other words, what it means is that if this was someone you regarded as a human being, you wouldn't have done this. Or if it was someone you like, or someone, you know, one of the other people who might be having impeachment proceedings. If they are sick, there would be an automatic adjournment. So the only reason why you treat this particular person this way is because you are biased against them. There can't be any other explanation. There's nobody in this world, lawyer or no lawyer, who doesn't know that proceedings must be postponed if somebody is sick. Then we Chair, from section E, we just show that there are other grounds of review. I'll just give you an example. I've already touched on it. One of the grounds of review in section 6.2D of PAJA talks about making a material error of law. So that's a ground of review on its own. The other ground, there's another ground which talks about the empowerment, breaching your own empowering provisions. In other words, you've got the provisions that bring you here are the rules of parliament, the directives, the terms of reference and whatever, and the constitution. So if you breach those, then you are committing a material error of law. And I've already touched on the situation where this committee has breached its own directives. So that will be a ground of review on its own, that either allowing cross-examination by people who are not allowed to cross-examine, or allowing members to ask questions before the cross-examination is finished, when your own empowering provision says it can only happen thereafter. Then, Chair, I then go and I'll try and kill two birds with one stone here. Again, at section F, we say the case against Mr. Mileham. And we do this also for illustrative purposes, just to show that that case against Mr. Mileham is completely, but completely unanswerable, despite all the things that have been presented to this committee. But forget about the things that were presented to this committee, which hold no water. The problem is that the committee accepted them. I mean, you know, unquestioningly. The two so-called defenses put by Mr. Mileham is that he said he's not a member's member. And in other words, he makes up his own mind about these things. But that's not the point. The point is the quotation we have in paragraph 44 from Hoekstra, who's the foremost expert on these things. She says, Professor Hoekstra, a family relationship, friendship, or enmity gives rise to a personal interest, real or apparent, that disqualifies the decision maker. Okay, it can't be clearer than that. So it doesn't help for someone to say, no, me, not me. It might affect other people, this family relationship, but me, I'm very independent. It's irrelevant. it's automatic disqualification. Chair, I mean, again, some of these things really is just logic. You don't have to be a genius. If Chair, I'm chairing something and you have a dispute between yourself and my sister, and then you come to the dispute and I'm chairing, honestly, you don't have to be a lawyer to say, no, here I'm getting a raw deal. You know, again, I might be the most independent person in the world, and I might even find against my sister, but that's irrelevant. From your point of view, you can't be expected to put yourself through that and still call it justice. Now, here, Chair, I would like to refer the members to, if you can put this one up, I will appreciate. The case of Liebenberg versus Brakpan Liquor Licensing Board, 1944 WLD. That case is exactly on point. In that case, what had happened is that a mayor of Brakpan was sitting as part of a committee that was going to decide liquor licenses. And his brother, Mr. Mitchell, was one of the applicants. And he was told that, look, you can't sit. He said, no, I'm very objective. Me, you don't know me. And, but the court said, no, but you can't do that. It said, among other things, the absence of impartiality and the presence of bias may often be hard to prove. But the courts disqualify for judicial work not only persons who in fact are biased and not impartial, but those who are probably so. In other words, by the mere fact of the relationship that this is your brother, you are probably biased. You may not be really biased in real life, but that's completely irrelevant. And then the court also said, Mitchell, that's the mayor now, ought to have recused himself immediately, but his standards appear to be different from those commonly attributed to the ordinary reasonable man. In other words, he should have known that this is not done. And then here's what the committee, an indictment on the committee, because now the judge was talking about how the committee should have charged Mr. Mileham. It says, to dismiss in one word the protestations that the members of the board of this committee did their duty properly, I need only say that according to the cases, this consideration is irrelevant. If in fact a person is biased or likely to be biased was one of the group of judges. So if he's one of the group of decision makers, says the fact that the committee says allowed him to continue is irrelevant because it doesn't change his bias. Right. And then one of the things that was said is that there was no application made for the recusal of this person, but here, unlike here, where there has been an application. And the court judge said, at common law, this case is too clear to merit detailed consideration. That's what I mean when I say this is a slam dunk cases. It's unanswerable. Plainly, there was a real likelihood of bias in Mitchell on account of his blood relationship to the second respondent. Were it necessary for my decision, I should not hesitate to hold that actual bias has been proved. Let me pause there. So the judge went on to say, this is not even a case of reasonable apprehension of bias. It's actual bias for someone to sit when their family member is a party. If a case so scandalous, says the judge, succeeded in passing the scrutiny of the court, the standards hitherto applied by judging of such matters would have to be revised and the principles of natural justice modified. So if such a scandalous thing would be allowed to go, they say you'll have to change the rules of the law of natural justice. It's nothing less of scandalous. But if you don't see it, you don't see it. And then it says the law draws no distinction between actual bias and real likelihood of bias. And I hold that this includes cases where a real likelihood of bias has been proved. As in my opinion, it is proved where a brother elects to be a judge in a competition for the grant of liquor license amongst a number of applicants, one of whom is his own brother. And then it says, amongst them are the spouses. Okay, here, then there was some clever argument which was put there, which basically is fatal even in this case. So the lawyer there, Mr. Price, said, no, the only people who are excluded are spouses. Now here we're dealing with the spouse as it happens. But the judge even rejected that. It said, no, even if you are a brother, that's enough. And it says, amongst them are spouses to put it shortly, persons engaged in the intoxicating liquor trade in that matter. The intimacy of the married relationship may well give a spouse such an interest in the trade as will place him or her in much the same position as the actual trader who is disqualified by section for appointment. Hence, the general disqualification of a spouse, even for appointment. But the fathers, brothers, and other near relatives of traders are not at all in that position. It would be absurd to disqualify them for such, even such appointment. But it is by no means to give a court the power and so on. And then the court said, yeah, to basically rubbishing that argument of trying to distinguish the brother from a spouse. But the point I'm making is that even in that case, the spousal disqualification was accepted as God-given, as it should really by any right-thinking people. Now, so the first thing that says no, and you'll see that when we deal with the Pinochet case. In the Pinochet case, it is said again that when you're talking about this kind of interest of a relationship, either blood relationship or one by marriage, you don't even have to go to the stage of, is there a reasonable apprehension? It's an automatic disqualification. It's just a no-no. You just don't do that. But what makes it worse in this case is the issue of non-disclosure. Non-disclosure is said to be a complete disqualification as well. Now, Mr. Milham says, I don't know what you're talking about, because I disclosed this matter in the parliamentary register. And the parliament even celebrated the marriage. I mean, really, what has that got to do with it? The law is very clear. You can't say, I've disclosed it to some other people. You must disclose it to the parties. In other words, must disclose it to the public protector in this case. You can't, this would be like in the case of the judge who holds shares, as I explained. If the judge says, no, but I don't know what your clients are complaining about, Mr. Mpofu, because I disclosed these shares in the registry for judges or whatever. I mean, everyone would laugh that out of court, yeah. Because that's why the judge called me and disclosed it to me, so that I can tell the parties. He couldn't say, well, it's your baby. You should have just read the judge's disclosure somewhere in the Chief Justice's office. I don't know where these things are kept. Yeah. So the disclosure that we're talking about is the one that should have been done here to the public protector, not in some register. And the independent or legal opinion people accepted that kind of thing. Yeah. So again, Chair, we're talking about a case that is not even debatable. A court will say you have now two unanswerable things: a relationship of marriage, admitted; non-disclosure, admitted, because the other non-disclosure is just not something that can be taken seriously. So in which world then can it be said that a person in that position who has hidden the relationship, and number two has is in the list of people who disqualified, must continue to sit here and judge just because he says that he's fine. That doesn't work like that. So I say, Chair, maybe, and this is a blanket statement which I'll make against you, against Mr. Malham, against the committee, and against the independent opinion. If you read those documents, you'll find in my view, I'm not conflicted. It doesn't matter. It's got nothing to do with your view. It's the perception, a reasonable perception of the public protector who's faced with that situation. That's the test. We can have your view as much as you like. And that's why we make this point about Mr. Malham's tweets, for example. When Mr. Malham puts his tweets and insults me and say something about my intelligence or whatever, me, I'm talking about myself. It doesn't matter. I'm also like you. My views are completely irrelevant. I might be annoyed by Mr. Malham's insults, or I might not be annoyed. It doesn't matter. If I am annoyed, I'll sue him or do whatever I have to do if he wasn't protected by the privilege. But that's got nothing to do with it. I'm irrelevant in that. The issue is whether the public protector in her position will believe that somebody who has attacked in public on Twitter, her legal representative, whether she must expect that person to be assumed to be neutral. And that's just ridiculous. So it's not how annoyed I might be or whatever. That's my baby. It's got nothing to do with her. But anybody who is human must just put yourself in her shoes and say, what would you do? Let's assume this was a court case. There's a judge, and you argue in front of this judge. And then on the Sunday, when you are reading the Sunday Times, you hear that this judge has been insulting you. And then on Monday, you must go back to that judge. And they call that justice. Anyway, so those are the issues. And the committee, I mean, really, this committee, Mr. Ngola, I hope he is listening here. Even Mr. Ngola, of all people, said here, before, when we did the application, members must refrain from attacking or involving themselves in anything to do with this case on social media for obvious reasons. And he was right. But when it came to voting, this committee voted that, no, there's nothing wrong with that. Let's go. There's no reason for recusal. Let's just proceed as if nothing has happened. We call that a reasonable committee. And Chair, you blame me when I say I know what's going to happen. If something like that can be seen by anyone to be okay, not even one word to say, okay, it's not, anyway, it's fine. But anyway, the committee endorsed that and said it's all systems go, there's no problem. There's no problem about the spousal relationship. There's no problem about the non-disclosure. There's no problem about the tweets, says our committee. Anyway, that then takes us to the Pinochet case, Chair. The Pinochet case starts from page 50, and forgive me, Chair, I'm just going to read this because, again, I don't want to bore you with the facts, but for those who haven't read the case, this case happened is that dictator called Pinochet, who was a puppet of the West, like other leaders, and there was an issue about his extradition, and this guy had literally butchered anybody who knows the story of Pinochet. But anyway, Amnesty International was one of the bodies that was participating in the case. Now, there was a judge called Lord Hoffman in the House of Lords, and we should be proud because he's originally from here, but he rose in the ranks of that place to become a lord, and he has ties to South Africa. One of the bright people that are associated with this country, very bright. So Lord Hoffman, his wife, was involved with Amnesty International, and he himself was chairing one of the charities of Amnesty International. And then the case went on. I think there were 5 of the so-called lords who were sitting in this case. And then they made a decision. Pinochet, the dictator, then, unfortunately, these cases involve very vile people there. So Pinochet said, no, I've just found out afterwards that there's this linkage with Amnesty International. The House of Lords said, there's no way that this case can be allowed to proceed, because we set aside the decision because Lord Hoffman, A, should have disclosed that he's a member of Amnesty International, B, not a member, sorry, that he's associated, and all these other things, that his wife is involved there and so on. And B, it doesn't matter. In fact, the lords were at pains, every one of them, there were 4 of them who gave, they all said, we believe Lord Hoffman, he's not biased, we know that, but that doesn't matter. The point is, what would a reasonable person in the position of Pinochet think? And then they quashed the thing. This is what they said, Chairperson, starting at 50.1, some of the highlights. And again, this talks to you and Mr. Milham and the committee. One of those, Lord Gough, he was called, Lord Gough of Chevalier, said, quote, in my judgment, the case falls within the first category, namely, where a judge is disqualified because he's a judge in his own cause. In such a case, once it is shown that the judge is himself a party to the cause, in other words, a complainant or whatever, or has the relevant interest in the subject matter, he is disqualified without any investigation into whether there was a likelihood or suspicion of bias. The mere fact of his interest is sufficient to disqualify him unless he has made a sufficient disclosure. So there it killed 2 birds with 1 stone. The mere fact of the non-interest, and it said that can be ameliorated only by disclosure. Why is that so? Because if you had disclosed, then I've explained this earlier, then the litigant might have waived their rights. And he says, I will call this automatic disqualification, said the Lord to that. And then the next Lord, Lord Brown Wilkinson, said, quote, there is no room for fine distinctions if Lord Hewart's famous dictum is to be observed, that it is, quote, of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done. Then the next one, Lord Hope of Craighead, said, only in cases where a judge is taking an active role as trustee or director of charity, which is closely allied to and acting with a party to the litigation, should a judge normally be concerned either to recuse himself, and here's the important part, or disclose the position to the parties, not to Parliament, some parliamentary register, disclose to the parties, in other words, to the public protector. However, there may well be other exceptional cases in which the judge would be well advised to disclose a possible interest. So again, the possible interest must be disclosed. Then the next Lord was Lord Hatton. This is what he said. It is no answer for the judge to say that he is in fact impartial and that he will abide by his judicial oath. That's the special about the oath that was from the so-called independent legal opinion. The purpose of the disqualification is to preserve the administration of justice from any suspicion of impartiality, not real impartiality. The disqualification does not follow automatically in the strict sense of that word, because the parties to the suit may waive the objection. I've already explained that. But no further investigation is necessary, and if the interest is not disclosed, the consequence is inevitable. In practice, the application of this rule is so well understood and so consistently observed that no case has arisen in the course of this century where a decision of any of the courts exercising a civil jurisdiction in any part of the United Kingdom has had to be set aside on the ground that there was a breach of it. That's what they're saying. It's so obvious that there was not even a case for a whole century where someone tried their luck by saying, no, I'm a spouse, but I'll be objective, or I didn't disclose, but I must be exempted. In a century, but here we've got it here in South Africa in a quarter of a century. As I say, South Africa alive with possibilities. Now, we say that it should be clear from these statements that when applied to the present inquiry, it would be unlawful, futile, and wasteful to insist on continuing with this committee pending the review application. Such a decision can only come from spite, but will in any case be not rational. So even if from hatred, one doesn't want to, just wants to in cause of challenge is phobe, just carry on irregardless, irrespective of what will happen or regardless of what might happen. That's fine, you can do that because you've got the power. But it will just be a waste of time on these facts. If I'm Chair, I know that I'm probably coming closer to the time, but just allow me one more quotation from Pinochet's case. I just want to stress the point that the subjective bias of the person is not important. Lord Brown Wilkinson said, it is important to stress, it's not one of those, it is important to stress that Senator Pinochet makes no allegation of actual bias against Lord Hoffman. His claim is based on the requirement that justice should be seen to be done as well as actually being done. There is no allegation that any other member of the committee has fallen short in the performance of his judicial duties. So even Pinochet accepted that Lord Hoffman is not actually biased, but he was still disqualified. And then that same Lord said, although this is an area in which legal technicalities particularly to be avoided, it cannot be ignored that Lord Hoffman took no part in running Amnesty International and that they are separate, whatever, but still they found him to be disqualified. And then he said, I think that the connections which existed between Lord Hoffman and Amnesty International were of such a character in view of the duration and proximity. Now, I can't think of any better proximity than between husband and wife. But duration and proximity as to disqualify him on this ground, in view of his links with Amnesty International as the chairman and the director, whatever, he could not be seen to be impartial. There has been no suggestion that he was actually biased, but his relationship was such that he was in effect acting as a judge in his own cause. I consider his failure to disclose these connections leads inevitably to the conclusion that the decision to which he was a party must be set aside. And that's what is going to happen to the decision of this committee.
You're stating that as fact?
Yeah?
You're stating that as fact?
Yes.
Oh, okay. Okay.
Sorry.
Proceed.
Yeah, no, Chair, you and I outside will make our bets. Yeah, but I'm simply saying that there is I mean, it's unfathomable. Maybe that's what, I can't put it higher than that, Chair, that there's any court in this land or any land that can say that you don't disclose a spousal relationship to a party, but you must not recuse yourself. But miracles do happen, especially in South Africa. Now, so Chair, maybe it's overconfidence, but I think it's it's a calculated guess.
I won't blame you for overconfidence.
Yeah. Then Chair, there's just one more where they say, like my noble learned friend, this is one of the laws. I'm of the opinion that the principle which governs this matter, that a man shall not be judged in his own cause, nemo judex in sua causa. The principle is not confined to a cause to which the judge is a party, but applies to causes in which he has an interest. Perhaps, for example, a judge who holds shares and so on, but we've already gone through that. And then he says, the question which arises is whether his connection with that party will, subject to waiver, make it clear, I think, that my decision is not that Lord Hoffman has been guilty of bias of any kind. He was disqualified as a matter of law automatically by reason of his relationship. I think, Chair, it's very clear. The last one, they say the fundamental principle is that a man may not be, but in some other way, his conduct or behavior may give rise to a suspicion that he's not impartial. For example, because of his friendship with a party. So even friendship may disqualify you, let alone married relationship. This second type of case is not strictly speaking an application of the principle that a man must not be a judge in his own cause, since the judge will not normally be himself benefiting, but providing a benefit of another kind by failing to be impartial. Now, Chair, I'm taking your challenge again. I'm saying that on those facts, it's barring, all sorts of miracles happen. There's no ways that this case, when it goes on review, it will not succeed. I've just spoken about some of the 12 grounds and some of the grounds to do with Mr. Mileham. But I don't have to be 100% right, Chair. All you have to be convinced when you're having your deliberations is that, let's put it at its lowest, there's a reasonable possibility that the review will succeed. If that is so, then anything you do from now on will just be wasting taxpayers' money, where you could have just waited and then proceed, subject to all the protections that we might build in if we decide to discuss the way forward. Then, Chair, lastly, thank you, Chair, I want to deal with what I call the practical proposals. In your letter, you invited us to indicate, and I appreciate that, Chair, I must say. Okay. Whoever advised you to do that got you some points. Because at least it makes it look like there's an open mind there somewhere. But you correctly asked us to say, okay, please indicate, and I think it was in the proper discharge of your duties, Chair, to say, well, indicate, are you saying that the thing must be postponed while you review the decision of the Chair and of Mr. Mileham and of the committee until you go to the Constitutional Court one day, which we know can take years? Or are you saying that you want it up until the High Court? In other words, to get, as I say, maybe because of what you've accused me indirectly of overconfidence. We are saying, Chair, we understand where that question comes from. And as a compromise, if you like, what we're asking for is a postponement only to the extent of the High Court. Firstly, because we think that would be sufficient because the case is so open and shut, but also because it would just take too long to go the other route. And therefore, we're hoping that if in the event of an open-minded committee, that would have been seen as something that we can work with, all of us, to say, let's at least get to the High Court stage. The second thing, Chair, is that what I hope, again, a reasonable committee would do is to say, let's avoid a situation where there has to be an application for an interdict and then the actual review, because then that will take us to forever, because the interdicts might be appealed and all sorts of things. And we could agree that, look, let's cut all that. Committee will postpone for a reasonable period. And you say to us, you must bring your application also within a reasonable period. And when the High Court has decided, we resume. And that would be something that would be practical. It would cut away 2 cases. It would cut away the SCA and Constitutional Court and what have you. And it would make it tight and more predictable. And I take your point, Chair, when you said to an unspecified date. That's true. But at least it would bring some level of certainty. But nobody can say for sure, well, we'll start on the 23rd of January or the 2nd or whatever. And let me give you an example, Chair. Rule 53, which is the way how you bring reviews. It's been bandied about here, but let me just explain what it says. Rule 53 gives the following steps for a review. And that is now cut out any interdict or anything. And let's assume for a minute that each of those steps would take 1 week, which is ridiculously impossible. But I'm just doing it for illustrative purposes. So we would give you the application next week, let's say. And then the week after that, you have to give us the record of the decisions. Then the week after that, we'll do the supplementary affidavit based on the record that you've given us. Then number 4, the week after that, the Parliament or the committee would do an answering affidavit. Then the week after that, we would do a replying affidavit. The week after that, we'd do heads of argument. And then the week after that, the other party would do heads of argument. That's impossible, as I say, but let's just use that as a yardstick. If that happened, then the matter would be heard on New Year's Day, which is if you just took 1 week. Now, as I say, that's almost impossible, and we're not even factoring in the availability of judges and all that. Yeah. So that's the kind of time frame we're talking about, Chair. On the best case scenario, in other words, where there's no interdict application, where we have sat down and mapped out a program for the hearing, and where we present that to the Judge President to say, please accommodate us within this period and give us a judge or judges. So that would be the best case scenario. The worst case scenario is there's no agreement. You find that you don't want to postpone, and we have to go to court and without any agreement as to how long it will take. Well, then nobody knows what would happen. That might take literally years and years. And I don't think it's in anybody's interest to go that route. Yeah. So we say then, Chair, that we then project that the hearing would be, let's say, around about January. And then the dates that we give are indicative. And then maybe somewhere after the SONA, we would be able to resume, depending. Obviously, we can't predict how long the judges will take. But again, if parties approach the judges jointly, we are able to say to the judges, look, this is important. We're not imposing on you, my lords, and this and that, but we'd like a quick outcome. It is known to happen. And then we say, obviously, if no agreement is reached and the matter is to be taken to court in respect of Part A for the interdict and Part B for the review, it would be impossible to predict how long the process might take until it reaches the final judgment in the Constitutional Court. This may take a year or two. Chair will then say we're available to take any questions on these submissions. And then in the totality, we ask that the committee either to grant the application for adjournment for all the reasonable, for the reasons that we have said, or to engage the public protector and her legal team with a view to reaching a mutually acceptable arrangement to cater for the period between now and the determination of the review application by the High Court, if you remember what I said earlier. Chair, thank you very much. I'd like to wrap up by just taking the 4 minutes as follows, Chair. This is it's a very serious matter. And as I said, that it's much more serious than the recusal application, because this one involves our parliament, at least, which may act either in a way which is in contempt of court or act in a way that is responsible. And I dare say, Chair, that if we are not driven by emotions and hatred and all sorts of vindictiveness and all sorts of things and bias, I dare say, then the outcome of this should be very obvious, which is that let's rather do a reasonable accommodation of each other and find a way to balance the interests of finalizing this matter with the interests of the public protector being able to enjoy her rights, which are enshrined in Section 34 of the Constitution, to have an impartial decision maker to decide her fate. She's not asking for much. She's asking for what you promised in the rules, that there will be a fair process and one that is biased people sitting in them are two diametrically opposed things. So the promise of a fair process cannot be achieved by this committee as currently composed. It's just an impossibility. The second way to look at it, Chair, in closing, is to say, okay, and that's why I've been at pains to say, I'm not convincing you to recuse yourself. We've gone past that. You've made your decision. All I'm saying is that there are two positions now. You say there's no grounds for bias. We say there are 12 grounds for bias. We say in the case of Mr. Mailham, there are 2 grounds for bias. He says there are no grounds for bias. Fine. It's a free country. So all we are saying is that let the court decide. You may be right, we may be wrong, or vice versa. And what I've been at pains to show you today is that we are probably right. But as I say, you don't have to believe me. You just have to say that on these facts, let the courts, let somebody who's not you or the public protector decide whether this is a fair process with when it has somebody who has already prejudged her to be incompetent, or when it has somebody who is married to the complainant, or when it has somebody who has not disclosed that connection, except to some MPs somewhere or to the speaker, who's not even a party to this. And it's up to you, Chair. The test is very clear that it's not, and that's why you'll see what somewhere in my writing I said I'm pitching this particular application not on the basis of actual bias, deliberately. I'm pitching it at the level of a reasonable apprehension of bias. I'm happy to do that. So assume that for all intents and purposes, both you and Mr. Mailham are the fairest people ever produced by this country. That's not the point. The point is the reasonable apprehension of the public protector. And I don't want to pitch it higher than that. And at that level, anybody who is neutral, objective, and fair will know that from the point of view of the public protector, on these facts that are before this tribunal, there is no ways that either you or Mr. Mileham or both are not automatically disqualified. Thank you, Chairperson.
Thank you, Advocate Mpofu. You would have, there's a new possibility you have created. You would have started at 8 minutes past 10. And you have this one of the shortest extra times you've utilized, about 11 or 12 minutes, 13 minutes. Thank you very much.
I've learned from you, Chair. I've learned from your time analysis.
I still do. Thank you for that. For now, we will, because I could see the public protector standing up, and I was responsible for that because we didn't have a break. So we'll take a 15-minute break and come back and follow the other matters. Thank you.
Thank you. Thank
Recording stopped.
Briefly, I'm going to ask evidence leaders if there's any clarity sought from your side. Advocate Mayosi.
Chair, thank you, Chair. We do wish for an opportunity to address one aspect that arises in the written submissions of the public protector in support of today's postponement. Chair, the evidence leaders do not play and have not played a role in the decision-making of this committee in respect of postponement applications, and we do not intend doing so. But we do wish to respond to an assertion that is made in paragraph 15 of the written submissions in support of the postponement that is sought today, insofar as that paragraph is directed at us. So it is said in paragraph 15, although the adjournment application is still to be made, past experience has made it easy to predict that whatever the merits of the application, the majority will almost certainly find against the PP, especially if the evidence leaders oppose the application. In the unlikely event of a different decision, this prayer will simply be abandoned or not pursued. It's this assertion, Chair, that we wish to address, the imputation of a certain outcome of this application, but in particular, if that outcome is supported by the evidence leaders. There's no postponement that has previously been sought by the PP and her legal team that the evidence leaders have opposed since these proceedings began. Members will recall that this is not the first postponement being sought by the PP and her legal team. For instance, when these proceedings began, Mr. Mpofu sought an adjournment of the proceedings of this inquiry in order to attend to the full bench hearing before the Western Cape High Court, where the PP sought to challenge her suspension. The proceedings then adjourned sometime in July. I think it was on the 25th for this purpose, and they resumed again later on in July. This was not opposed by the evidence leaders. On some occasions after that, the PP's legal team have requested the rescheduling of hearings so that they could attend to other litigation commitments, such as, for example, when they had to attend to the PP's criminal proceedings for perjury. The evidence leaders didn't object to this. On the whole, Chair, the evidence leaders have adopted an accommodating rather than an oppositional stance in relation to requests of this kind. We have done so notwithstanding the personal impact that these delays cause to us as external legal counsel who have practices of our own and other clients to attend to. The PP's request for a postponement on the 13th of September was not opposed by the evidence leaders. Rather, as the chair and members will recall, during the proceedings on that day, we sought clarity from Mr. Mpofu regarding, amongst other things, the postponement that he was asking for. In other words, was it an adjournment of the proceedings until the PP's litigation was finally determined, or was it only a postponement until after the hearing of the PP's application on the 16th of September? This was not opposition to the request for a postponement, but it was rather an attempt on our side to ascertain whether the postponement being asked for was going to result in an indefinite delay, which in turn impacts on us and our ability to make ourselves available for these proceedings. So Chair, given that there are no postponements that have previously been opposed by the evidence leaders, it's not correct to say, as it is said in paragraph 15 of the written submissions in support of today's application, it's not correct to say that based on past experience, the PP can easily predict what the outcome of this application will be, especially if it's opposed by us. As far as the evidence leaders' opposition of applications of this nature is concerned, we say there's no past experience of this. To be clear, Chair and members, the evidence leaders are neutral regarding both the merits and the outcome of the present application. We are not decision makers in regard of this application. The chair and the committee are the decision makers, and we will act in accordance with whatever decisions are made in that regard. It's important for us, Chair, as evidence leaders, to place ourselves on record in regard to this assertion, particularly because in the written submissions that were made in support of the PEP's application for the recusal of yourself and Mr. Milam MP, one of the grounds relied on there was phrased as unduly favoring the evidence leaders and unwarranted proximity to collusion with them, and so on and so on. We addressed this accusation of collusion and others orally on the 21st of September. And the record will reflect what we said there. We don't intend to repeat it. We denied this. And to the extent that this inference is being raised here again, we deny it. Suffice to say, Chair, that this assertion made in paragraph 15 has the same collusive connotations as what was said in the written submissions in support of the recusal. We will, throughout these proceedings, seek to address, deny, and place our denials on record each time such aspersions are made against the evidence leaders. They are unfounded, Chair. In fact, to borrow from the PP's phraseology, based on past experience, assertions of this nature have tended to be used to impugn the character of the evidence leaders as legal professionals, which in turn can and has been used as a tool to attack the integrity of this Section 194 process. Hence, the need to place our position on record, Chair, whenever this occurs. Thank you.
Thank you, Advocate Mayosi. On that, I will proceed, honorable members, to you. I'm going to ask you to, at this stage, just stay on clarities so that you don't, when you get into deliberation, say you did not understand what the PP was saying on the application. Any issues that you are uncertain about, you need clarity on, I want to open up opportunity for that so that we don't get into the merits of what would have been placed in front of us. I'm going to invite you to seek those clarities so that after that, I'll revert to Advocate Mpofu to have those kind of responses. Any members wishing to seek clarities? I see Honorable Ngola on the virtual platform. Honorable Aaron. Those are the only 3 members. Are there any further members on the virtual platform that wishes to make any clarities? Honorable Zungula. Thank you. I think those are the members I have indicating to make clarities. Then there's a late comer, Bekizwe Ngosi. Thank you. Here at M46. Honorable Sukas. Thank you. In that order. Honorable Ngola, you have the platform.
Thank you very much, Chairperson. I just only have one question. And the question is, can a contempt of court arise if the court has not adjudicated on an application, particularly when the application has not been lodged but there is an intent that has been indicated to launch that particular application. That is the only question I have, Chair. Thank you.
Thank you. Thank you, Honorable Nola. Honorable Heron.
Thank you, Chairperson. Chairperson, my question is about the proposals with regards to a reasonable period of time to bring the review application. I see in the application for the adjournment at paragraph 56, there is a proposal that the application will be brought by the 31st of October. So I just want clarity if that is still the proposed date by which the application for review would be brought, and that would be considered the reasonable period of time, because I don't think Advocate Mpofu in his oral submissions referred to what date they had in mind for bringing the review application. Thank you.
Yes, before I let you go, he would also have indicated, Honorable Heron, that date of the 31st would largely depend on the outcome of today's meeting, but I will leave that to him. I was just raising you in order you want to have a follow-up, but that's what I had him presenting. Thank you, Honorable Heron. Honorable Zungula.
Thank you, Chairperson. I've got a couple of questions. One is linked to, similar to what Honorable Ngola was saying about the contempt of court. So I think I'll just let that one go. Then my first one.
If you could also just assist, come closer to your mic so that we can hear you properly. Good.
Kungcono ngokuhlala.
Voice yakho is strong, but namhlanje angathi down. I don't know whether it's our system or what. We're also asking them to increase the volume. Let's try again, Honorable Zungula.
Bandikwaza sihlalo ndiyavakala.
Hayi ndakubona uyazama Koba.
All right. I've got a couple of clarities. The first one is that the chairperson says he's taken oath of office. Does that make the chairperson be immune to bias? Then secondly, if we continue as the committee in face of such a clear-cut case, who will be liable for the criminal case of contempt of court? Will it include also people who would be against us proceeding as a committee, or every member of the committee will be liable? Or is it Parliament? But the biggest issue from my side as to who will be liable for the contempt of court. Uzokumbula, Chairperson, abantu bayabanjwa when they are contempt of court. So that's why I need to understand bangubani exactly will be liable for being contempt of court. Then the third question is, the chairperson denies shouting Advocate Mpofu on the 13th of September when he tried to present the medical certificate. But everyone who was listening, I think, would have heard him. Will the review court have access to the YouTube material? Then the last one, what are the possibilities of getting an earlier date, no later than January? Those are the only questions. Thank you, Chair.
Thank you, Honorable Zungula. Honorable Paikizwe Nkosi. Honorable Nkosi. Honorable Ngosi, are you there? It's very quiet. Jups style. I will come back to him. Honorable Sukas.
Thank you, Chair. I don't think mine is a clarity-seeking question, but I have a concern, and it seems that Advocate Mpofu was indicating that the public protector may withdraw from the process, and I think I just want to ask the question that was actually mentioned by Honorable Mulder some time ago when he said that there is no guarantee that the public protector would put her aside to this committee, given that she was indicating then that she would answer only on written questions. My question is whether the public protector, Mr. Mpofu, can indicate whether the public protector is going to give evidence to this committee.
You done? You got that, Advocate Mpofu? Okay, thank you, Honorable Sukas. Honorable Malema.
Thank you very much, Chairperson. I just want to ask Advocate Mpofu as to how do we navigate the fact that there is no case before any judge as we speak now? Because ordinarily, we will say, now that the matter is before the court, we can't proceed with this matter. But in your own submission, you said you're 60% ready to complete the papers. So meaning there's no case number or any court before, any papers before the judge. On which basis are we going to base our argument of postponement? I heard you quote in some cases that says if you are made aware of the matter being before the court and you still proceed, you may be in contempt of court. But from a layman's perspective, and this is the argument we've always used in Parliament, that if the matter is before court, we can't even debate it in the full sitting of Parliament, worse in this. But there's no matter before court. And I was going to be more comfortable if there was a matter before court where the chair and the committee or whoever is served with papers. And as we speak now, we've got papers that have been submitted to court, a case number has been released, and all of us have been made aware that we are respondents, and therefore let's leave the matter before the court. So I'm troubled by that issue, so I hope to get the clarity from you. Thanks, Chair.
Thank you, Honorable Malema. Honorable Bhekizwe Ngosi. I hope your line is back. Honorable Ngosi. Can you talk to us? We can see your picture. We suggest that you log out and join again. You have a problem there. Thank you. Whilst we're waiting, is there any other member? Because I don't want to invite Advocate Mpofu and then there's somebody else who wants to come in. Honorable Kondo.
Thank you very much, Chairperson. I think I have two questions.
Just raise your voice.
Two questions of clarity, Chairperson. In his opening remarks, Advocate Mpofu stated that no one wants the inquiry to proceed as much as the PP does. And then my question becomes, if indeed the PP does want this inquiry to proceed, why then have we as a committee have had to sit through 3 recusal applications. And today we're sitting through an adjournment application. I mean, they brought these application in such a short space of time, one after the other. And, you know, for the ordinary person on the street, you know, they would think that the PP doesn't want this inquiry, you know, to proceed and for her side of the story to be heard. And we are really looking forward to hearing her side of the story. And so I also need to ask you, Chairperson, have the PP and her legal team finalized their list of witnesses that they would like to call? Have they submitted that list to you? Because, you know, we're really keen to hear her side of the story, and these recusal application and this adjournment application seems to suggest that she's not really keen on you know, proceeding with this inquiry. If she was, she would be rearing for this committee to hear her side of the story, and for her team to lead, you know, witnesses that would, you know, exonerate her from the charges in the motion. And so I'm puzzled. And then my second question becomes, so the adjournment application suggests that you know, this pending review proceedings, which haven't even been brought before a court of law, you know, should they be brought before a court of law come the end of this month, then, you know, and with everything that needs to take place, you know, in between, then we would then resume at the end of February and the beginning of March 2023. And by then, Advocate Mkhwebane's term of office is around the corner. It will literally be 6 months away. So does Advocate Mpofu think that we can, you know, we can conclude this inquiry within that 6 months? I mean, before her term of office. I mean, I'm puzzled. I would like clarity on that, Chair. Thank you so much.
Okay, thank you, Honorable Gondwe. Honorable Ngosi is the last one, and then we go to Advocate Mpofu.
No, thanks, Chairperson. My apologies for the lack of connection. My first question relates to exhausting the. You still can't hear me?
No, we can hear you now.
Oh, okay, thanks. My first question relates to exhausting the mechanism provided by the Section 194 committee itself. We are a creature of the legislature. Has the Public Protectors team considered approaching those that constituted this committee, meaning the Speaker and through the Speaker Parliament, to try to resolve the matters that they're bringing before us? If so, why is that not open to them? And why go to court on a matter that you can easily resolve through that process? Secondly, I think I had the legal representative, Advocate Mpofu, say that I've not found it in the paper, in the application, but I seem to have heard that he says perhaps you, Chair, and the evidence leaders can take an aside and try to iron these matters out and come back to the committee. In relation to that one, is that a commitment that whatever the outcome of that process will be accepted? Two, if that doesn't work, will they still go to court? Thanks, Chair.
Thank you, Honorable Ngosi. Thank you, colleagues, honorable members. I think at that point, I'm going to ask Advocate Mpofu to do the brief responses to the clarities that have been sought.
Thank you, Chair. In the interest of time, what I will do is I'll try and group those that are related. So, for example, the question from Honorable Ngola and the one from Honorable Malema, and another one of Honorable Gondo's questions are related in respect of procedure. So let me just tackle those very quickly. Those who were listening when I started, I said to the chair that the reason, and I don't know if members have access to the correspondence between the chair and I for the past week or so, and I won't go to it now, but let me just paraphrase. What happened is that, yes, our duty is to make the chair aware, or the committee aware via the chair, obviously, of our intended application. That has been done. The chair, when you are summarizing at the beginning, explained that. Now, the reason why there is no application before a court now, as we speak, is very simple. It is because, as we have said, the decision of this, otherwise we would go to up and down the courts, and the courts don't like their time being wasted like that. There are two primary decisions that will be reviewed by the review court. The one is the what I call the non-recusal decision. That decision has been made by three separate entities. And I don't mean by disrespect, let's say persons. Yeah. It's the chairperson, non-recusal decision. It's Mr. Malham's non-recusal decision. And the third decision, which is the important one, is the decision of this committee endorsing those two decisions. So that's the first cluster of what the court will have to review and see whether those decisions were rational, all those three decisions. But the second cluster of decisions is what you are going to decide now. All right. So we can't go to court. In fact, we even considered that, go to court and say we know what they're going to decide, because we do. But that won't be procedurally proper. We have to await the decision of today, because that decision, if it's adverse to the public protector, must also be reviewed because of the cases that I've cited, which say that you'll be wasting your time if you proceed knowing that there's a review application. Okay, so that's the first answer as to why it would be foolish to go to court and then there's a decision and then you go to court again. It's just not done like that. That's why the court in Pikoli's case said, and I put that right up front before my submissions. You'll see the preamble to the submissions. It says on page 1, in appropriate circumstances, an authority should halt, that means stop, its actions or the inquiry when it is aware that the review proceedings are to be instituted, right? Not have been instituted. When it's aware that they are to be instituted. Failure to do so may render the official concerned liable for contempt of court. In short, for the committee to be held in contempt of court, all that is needed in law is for it to be aware that there are review proceedings which are to be instituted. And it's common cause that that test has been passed here. Okay. All right. So that's the answer to the issue about whether it's true that in ideal world, it's better to say, oh, here's the case number and so on and so on. But in these situations, you can't. If you do that, you'll just be wasting the time of the court and you might be mulcted with a punitive cost order, because you know that generally you shouldn't review a decision preemptively. Okay. All right. So that covers, I think, Honorable Chair, please, if you indulge me. The first part of your question, Honorable Ngola, I think I missed. I got the part about the proceedings have not yet been in court, which I've just dealt with, but you had asked something else. Can I just ask him?
Whether
He said, he started by saying, can contempt be applicable if, firstly, he says, if the application has not been lodged, which I've dealt with. And then there was another one.
Okay, you want to complete that, Honorable Ngola?
No, Chair, I think Advocate Mpofu has captured the question
Covered.
correctly.
Okay.
Okay,
Thank you.
Yeah.
Thank you.
thank you.
Thank you very much. Okay, so that's that cluster of questions. So that's the 60% or 70% or whatever it is was about that. The other part is impossible. You can't do it until there's a decision here. Okay. And sorry, I don't want to get into legalese, but before there was something called constructive contempt of court and it dealt with situations like this. In other words, contempt of court normally is that you must have a court order and then you defy the court order. But constructive contempt means when you know, if I go to court and the court case is next week and I say, I want you to return my car, and then you sell the car, you can't then turn around and say, oh, well, the court was only sitting next week because you knew that, well, I'm going to court next week. So it's anyway. All right. Then Honorable Gondwe, I think let me just, since I've answered one of her questions, let me just finish with her. She says, if no one wants the inquiry to proceed, why do we have recusal applications? It's a pardon? Well, said, why do we have to sit through?
Order, Honorable Gondwe, you speak through the chair.
Well, yeah.
Even it doesn't matter how close you are with Advocate Mpofu. So, so if you want to clarify that, I give you that opportunity.
Okay.
Advocate Mpofu,
Maybe, Chair, in fairness, let Dr. Gondwe say her own question, but I wrote it down. Why do we have to sit through and all that? And carry on.
okay, my question was, you said in your opening remarks that if there's anybody that wants this inquiry to proceed, it is the public protector.
Yeah.
So my question to you was, if indeed she wants this inquiry to proceed, then why have we as a committee have had to sit through 3 recusal application and this adjournment application, if indeed she does want it to proceed?
Yeah.
And then I asked through the chairperson that, are you ready to lead your witnesses? Have you submitted, have you finalized your list? And are you ready to lead your witnesses? Because we are looking forward, or rather, let me speak for myself. I'm looking forward to hearing her side of the story. And if indeed she was raring for us to hear her side of the story and for this inquiry to proceed, then, you know, we would not be at this point.
You are puzzled. Yes, but that's exactly what I'm saying. I don't know where the problem is. That's exactly what I was saying. I can't answer all the 3 questions in one sentence. I have to do them one by one. So I was dealing with question number 1, which is, if indeed she wants to proceed, why do we have to sit through the recusal? That's exactly what I said. Is there anything wrong that I said?
Now proceed, Advocate
Mpofu,
I think.
Thank you. So let me answer that question. Yeah. As said before and as repeated now, the reason, madam, why you have to sit through a recusal application and the postponement application is because of something which is rare, called fairness. Okay, your committee is bound, has bound itself. It is bound by the Constitution. It is bound by the rules to act in a matter that is procedurally fair. Procedural fairness includes 2 things. One is called audi alteram partem, you must hear the other side. The other one is called nemo iudex, which is the rule against bias, right? Now, anything that lacks those 2 things is ipso facto not fair, right? So the public protector, when I say the public protector wants the inquiry to proceed, you must build in there the word lawful. In other words, the public protector wants a lawful process to proceed. She can't be keen to have an illegal process proceed. That would be madness. Okay. So what she wants to happen is a process that conforms with your own rules about fairness. Now, if one of those rules, which is the rule against bias, is being breached because sitting here in her judgment are people who are automatically biased, as I've explained, then it's like saying I'm just rushing for the sake of into a cliff. Rushing doesn't, you rush to the actual destination. You don't rush to an unfair, an inherently unfair process. So that's the answer. That's why everybody, including the DA, goes to court. They go to court to make sure that there's a fair process. That's what they did in the case of Palate. That's what they did in the case of all sorts of people, is to make sure. You can't say, if you want something to happen, why are you going to court? I mean, I can't claim to understand that. People go to court because they want that process to be done fairly and justly. Okay. All right. So that's why, unfortunately, the law, it's not me, provides for such a thing called recusal, because the law seeks to protect us, you and me, from kangaroo justice. It wants us to be subjected to fair processes, whether it's by a judge or a committee of parliament or a tribunal that's giving out dog licenses or tenders or whatever. There must be a fair process. Okay. Otherwise, you'd ask, why does the losing tenderer go to court? Because they know that someone was bribed or whatever. So what must they do? Because they want the bridge to be built, they must not exercise their rights. Anyway, you say that going to court or asserting her rights means that she is not keen. Yes, you're right. She's not keen to have an unfair process proceed. She's not keen to have the money of the taxpayers wasted in a process that is doomed to be found to have been unlawful. Because we can just do that to satisfy our insatiable appetite to hurt, but it's not going to achieve any process, any purpose, to just waste money and time, because again, you'll be rushing to a cliff, an obvious cliff, because the court will tell you should not have. It's as if you didn't sit at all, as I quoted from that case. And then you say you are puzzled, I think, as to whether, if the processes are followed, you'll be able to finish in 6 months. Again, that logic escapes me, because the target for you, for all of us, should be a fair process, not 6 months or 3 months or 10 years or whatever. The target is that we must have a fair process. If that can be achieved in 6 months, so be it. If it can be achieved in 6 minutes, so be it. But we can't be chasing minutes or days or weeks or months. We must chase justice. Right. Now, then you say that we're looking forward to hearing her side of the story. And that ties up with the question of Honorable Suka's chair. So if I can just combine those two. Yes, you are looking forward to hearing her side of the story. She's more than looking forward, I can tell you from personal experience. She's more than looking forward to giving you her side of the story in a fair inquiry, okay? So unfortunately, that's the hurdle that has to be passed. If you wanted to give her a side of the story in a, I don't know, in some hall, in a moving train somewhere, she doesn't want to give it there. She wants to give it in a fair inquiry that's properly constituted, that doesn't have people who are biased inherently because of their marital status or previous utterances or all the things that I've raised. Okay. And that goes to Honorable Sukas, says two things: whether the public protector will give evidence Sorry, I'm coming to the rest of your questions. Whether she'll give evidence, the answer is a big yes. She will give evidence once all the unfairness and bias and all that goes with it has been cleared. In fact, she's looking forward to it. If we could clear it now, she would give it right now. We are more than ready for that, yeah. Especially given the kinds of things that have been said here about her. She's more than keen. But what she will not do, it doesn't matter who says what. What she will not do is not to exercise her rights like all of us, you and me, and just, you know, walk into a lion's den to, you know, I don't know, expecting a Daniel miracle. Okay, so that's really all that is happening here. So and then you say the public protector, you said that I said that she's going to withdraw from the process. I don't know where you got that from. I never said such a thing. All I said is that the public protector wants to proceed in a just process, and that is true. That's always been true. It should be true for any other human being. Yeah, I think that covers Honorable Sukas. Now, coming back to Honorable Gonda's questions about a list of witnesses. We gave a list of witnesses in August, as you know. The Democratic Alliance issued that distributed that list to the public. We raised it here as an objection because that was objectionable conduct, to put it neutrally. And but that list you've got, so you for now you must live with the list that you got in August. If you want another list, you will get it when we're going to call witnesses. Whenever that is. There's a rule in this place. This is not, you don't just do things because you feel like. The rule says that you must give statements 7 days before calling a particular witness. And I can assure you will comply with that rule. I've spoken about it before. If we don't comply, it will be because of practicalities, just like the evidence leaders have not always complied with it. But as lawyers, we know that it's difficult to control human beings and witnesses. Sometimes it's not possible, but all things being equal, we'll comply with that rule. We can rest assured. There was something else. Oh, the puzzle. Yeah, okay. I hope that you're no longer puzzled by the fact that it might take 6 months or whatever it is. Doesn't matter how long it takes. The most important thing is that, and I think that links up with somebody else. I'm sorry, I can't remember. One of the members spoke about. Oh no, it is Honorable Kondo. You know, why doesn't she just put aside of the story and let's get on with it and all be happy? No, the law is exactly different. The law says that you must bring your application as soon as possible. You can't wait for the outcome. And then only when the outcome comes and maybe it doesn't suit you, you start saying, oh, what about Honorable Malham? Oh, what about this? What about that? It's not allowed because that's opportunism, among other things. You need to bring it. In other words, even if we succeed, let's assume the committee will find the public protector not guilty, or that there's nothing wrong that she has done. That's got nothing to do with whether the process is biased or not. Okay? So it's not about the outcome, it's about the process, it's procedural fairness. Okay. And this is what Chief Justice Ngobo said. It's not open to the applicant to wait for the outcome, at paragraph 71 of the APSA case. It's not open for the applicant to wait for the outcome of the appeal before pursuing his complaint of bias. It is highly desirable if extra costs, delay, and inconvenience are to be avoided. that complaints of this nature be raised at the earliest possible stage. A litigant should not wait for the outcome of the appeal before raising a complaint based on recusal, when all the facts giving rise to the recusal complaint were known to the litigant. The conduct of the applicant is simply inconsistent with a reasonable apprehension of bias. If he had any apprehension of bias, it must have been of the kind that he thought could be cured by a judgment in his favor. But that can hardly be said to be a reasonable apprehension of bias that is reasonably entertained. The applicants have wanted to have the best of both worlds. Okay, that's the law, according to the Constitution at least. So that's how it works. Yeah. So that's why I'm saying you have situations here where the highest court in the land has pronounced on these things. So it doesn't matter. I mean, if the court says that if you are married to someone, you are conflicted, but that person who's involved in that says, no, I'm not conflicted, who are you going to believe, the court or the person? It should be, the answer to that should be obvious. Yeah, so I think that covers those sets of questions. Honorable Sukas, we've covered. Malema, we've covered. Honorable Kondo, we've covered. Honorable Heron. Yes, no, the chair is quite right. The Honorable Heron. I did, if you like, water down the date of the 31st of October by saying that it's like a moving target. So by that I mean, let's say for argument's sake, this committee takes the decision next week on Wednesday. You can't then say to me, but you said you were going to bring the application on the 31st of October, because that will be the 2nd of November already. So all I'm saying is that it will be a few days after the decision of this. So it's an indicative date that we're giving. And already I can tell you now that that date might even end up being the following day or whatever for various other reasons which are not relevant. But the principle, as I said to the chair, and that's why the chair summarized it correctly, is that the application will be brought as soon as possible. And that, chair, ties up with another question from Honorable Zungula about what are the possibilities of getting an earlier date, no later than January. The possibilities, when I did that postulation, which led us to New Year's Day, I was doing exactly that. I don't know what the possibilities are because some of the things are not in my power. One is if this committee finds that it adjourns, I think it's possible that it can happen by January. But if the committee says it will not adjourn, then it's out of my hands. Two, the judge president has to allocate a date, possibly for a full court. But from past experience, I would say that the judge president has accommodated Parliament and us, especially, and that's why I'm so keen about this thing of negotiation, because we've had all the cases that we've done around this matter we have been able to negotiate as the legal teams of the president, the DA, the speaker, and ourselves, and do what we call a joint letter to the judge president, and then ask for specific dates. And if we do it like that, he almost invariably gives the dates that we've asked for. But obviously, if one of the parties says, no, I'm not available, and so on, then you can't force people to come to court. That's why negotiation is faster than litigation, just for the sake of litigation. So the January date is based on an optimistic projection that people will act reasonably, but that's not necessarily what happens. Okay, then Chair, yes, okay, that also covers Honorable Heron's second part of the question. The date of the actual review then would be, as I say, give or take around about January, if we jointly ask for it from the JP, and unknown if we don't.
Chairperson, may I just clarify?
Pardon?
Sorry, Advocate. I was
Is that
just
a
I'd
follow-up?
raised my hand.
Oh, okay, sorry.
I'm talking to the chairperson. I just wanted to clarify my question.
Yes.
Go ahead, Honorable Herren.
Thank you. I was actually, when I raised the 31st of October, just asking what is a reasonable period to launch the review application?
Okay.
If today is the 27th, the 31st is 4 days away. So if the committee was to agree to an adjournment based on you launching a review application, how long should that be?
Okay, yes. I don't know, there's a bit of an echo now. Okay, maybe I must not be too close. Okay, now I say, Honorable Herren, I think I've answered that question. I'm saying two things, that it will be as soon, if it's not the 31st, really, it could be before or slightly after and so on. The principle I'm saying is that we are committed to doing this as soon as, that's why I can assure you, we spent the past few days drafting so that we don't wait for this outcome of this application. And then we start again saying, the undersigned, Busisiwe Mkhwebane, and so on. All those have been done. The question now is, the only outstanding bit is the outcome of this application, because that has to be factored into the prayers. One of the prayers is to say that the refusal of this committee to recuse its to postpone is irrational because of the reasons I've explained. But for that to be a reality, there would have to be such a refusal. I can't explain that more than that. Yeah. So it's a moving target, and then I've also explained that if the committee, for some reason, for example, it says it wants to get legal advice or whatever, and then it gives the decision on the 1st of January, on the 1st of November, then you can't say to me, but you said you are going to do the thing on the 31st, because it's a moving target. I don't know if that covers you, Honorable Herren.
Proceed.
Yeah, but the principle is as soon as possible, within days of the decision of this committee, the application, and then from there, the thing will roll, as I've explained, until notionally New Year's Day or the first week of January or whatever. And I'm just doing that just to show the dates. I don't really mean we'll be in court on New Year's Day. Yeah. I was just showing the indications. Yeah. All right. Thank you, Chair. Honorable Nkosi. Before the only thing that's left now is the rest of Honorable Zungula's questions. Honorable Nkosi, exhausting internal remedies. Yes. Yes, Honorable Nkosi, that's a good question. And I think, again, with the interest of saving time, just after the recusal application, if I'm not, just after the recusal application, which was sometime in September. Oh, yes, 22nd, literally the day after, on the 22nd of September, we wrote this letter to, sorry, we're trying to move somebody else's, okay, good. Yeah, to the Speaker of Parliament. And we copied the chair of this committee. And it starts like this. As you may be aware, on 25 September, the public protector moved an application on the ongoing Section 194 committee for the recusal of the chairperson, Honorable Kubutile Janji, and one of the members representing the DA, Honorable Kevin Mileham, and so on. The purpose of this letter is to formally inform you of the above and to supply a copy of the application, or further instructed advise you that after the application, the committee duly adjourned the proceedings in order to deliberate on the recusal, and so on and so on. We wrote, yes, the answer is yes, we did do that. And the Speaker's response was that, which came on the 27th of September, was that it's not, she says not, it's the committee. She said, number 3, Dear Mr. Sianaho, the committee's function is independently within the confines of the assembly rules. The speaker cannot interfere, involve herself in the function of the committee, except to the extent that the speaker chairs the National Assembly. As such, the speaker is not in a position to respond to your request, and so on. The client is at liberty to take whatever course of legal action she wishes to, following considerations and decisions that emanate from the recusal applications. So that's done. Thank God. That's ticked. So we have no problem, because that would have been another problem, by the way, in the timeline. We would have had to escalate the thing to the speaker. That might take another 2 weeks or 3 weeks. Fortunately, we've already done that to save time, and she has already responded. So there's no further duty upon us to exhaust internal remedies, because the speaker has basically said the committee will decide whatever it decides. So that's done. Thank you. And we did it in the interest of saving time as well. Oh yes, the last question from Honorable Ghost was, if we have the boss Barad, where I was saying someone must lock us into a room and throw away the key, is that a commitment that whatever the outcome, it will be accepted? And if it doesn't work, are we still going to go to court? Well, the answer is, you never know. It's called in our trade settlement discussions. Settlement discussions are done in order to avoid prolonging time and burdening the court with obvious things and taking months and months to get a judgment and so on, in something that you could have resolved in an hour of talking. Yeah. But there's no such thing as saying, well, we'll go into settlement negotiations, but if they fail, we won't go to court. I mean, it doesn't work like that. The whole point is to avoid going to court by having those negotiations. But if they collapse, they collapse. Then we're back to square one. We were just giving a commitment from our side. Whether people believe it or not, we are committed to having this thing moving as fast as possible. And that's why we've taken all these steps of preempting, writing letters to the chair, writing letters to the speaker, so that there's no, if we wanted to waste time, we'd then be dragging, we'd say, okay, now we're going to spend another month writing to the speaker. Now we're going to do this. We don't want that. We want the thing to, in fact, you'll be surprised when you do hear our witnesses, you'll understand why we want it to come as soon as possible, but before a fair process, a fair committee. Okay, sorry, Chair. The last one is Mr. Honorable Zungula's three other questions. The chair says he has taken an oath of office. Is he immune to bias? Well, I think I answered that in my main address, Honorable Zungula. Nobody is immune to bias, not even the Chief Justice or the Pope. So no one can be assumed to be immune from bias, particularly it can be simply because they've taken an oath of office. And that involves, by the way, even this issue about the lawyers who were chosen by this committee. No one can be, there are rules of I wanted to make this example. Against myself, I've done cases for the UDM, for example, or the president of the UDM since 1995, almost 30 years. Yeah. So if this committee were to say it wanted to recuse Honorable Olomisa for some reason or another, while I'm doing a case for him, I wouldn't take that case. I mean, nobody says I shouldn't take it, but ethically, I wouldn't, because again, I could be the most objective lawyer in the world, but how is it going to look if I now take the same case for the recusal or non-recusal of my client? Because it will work against him either way, by the way. Either I will say he must not be recused, in which case I'll be accused of bias, or I must say he must recuse, in which case I'll be overcompensating. Yeah. But anyway, so that's the no one is immune. That's the short answer. No one is immune from bias. No, not me, not the chair, not anybody. And the oath of office, even of judges, doesn't immunize anybody from bias. Okay. And the test is objective, by the way. It's not the test of the reasonable chairperson. It's the test of the reasonable public protector. Who will be liable for criminal offense of contempt of court? Will it be every member of the committee? Excuse me. Theoretically, bearing in mind that contempt of court these days carries 15 months is no longer the customary 6 months. That will mean that no, I don't, and yeah, I'm speculating. I don't think those members who vote against the motion, we know the motion that's going to come, it's going to say, no, we are proceeding. So if I was advising those members who are not part of that, they should have their names registered so that it's known who is not part of that decision. Generally, without that, it would be what I call common purpose, because the committee in law is a person. It's not the individual members. So it's the committee that is biased because it took a majority decision. But criminal law is not, is a different kettle of fish. So the short answer is that—
wrap up now,
Yes, sorry, Chair. Okay, that's a short answer. It would be those who have taken that decision. That's what, although the Piccoli quote that I made says, if the tribunal or the official, they'll be guilty of contempt. And the official here is the committee. But I don't think it can be taken literally. So it's only those who will go for 15 months. Okay, now, then you say that the chairperson denies shouting and everyone heard him what, and the YouTube material. Yes, that's what, if you remember that when I was giving the stages of the Rule 53, one of them is the record. There isn't a review court because the review court is not here now. So the review court literally is going to go through the record of these proceedings from the first day where that is, and then we'll have to show them where the relevant, for example, where we applied about Honorable Mileham, where we say the chair was shouting and so on. And the record will include the audiovisual material. Actually, the law says every scrap of paper that informs that decision must be. So all these things, the opinion, the record written, the YouTube and what have you, will be part of that so that the court can assess for itself. So again, it doesn't matter if the chair says I did not shout or if I say he shouted, because both of us might be subjective about it. It's what the court will observe for itself, and it will say either I'm right or the chair is right. And then we'll move on. Last one, Chair. Later than January. No, I think I've covered that one. Thank you, Chair.
Thank you, Advocate Mpofu. Honorable members, we are now going to take lunch. I'm requesting that members, we come back at 1:45, but we'll excuse the evidence leader and Advocate Mpofu and the PP's team, so that we get into that slot whilst they're finishing their lunch. So that it's convenient for all of us. Thank you very much. It's a shorter lunch for us.
Recording stopped.
so that we're able to deal now with the next items, having excused the evidence leaders and the PP. Before I invite the members for their own deliberations, I'm going to invite our legal advisor, Ms. Fatima Ibrahim, to make important remarks or reflections, having listened. Ms. Ibrahim.
Thank you, Chair, and good afternoon to all the members and everybody that's on the platform online as well. Chair, I want to start by just reminding members of the nature of the committee and the standards by which the committee is bound in conducting its work, including the making of the decision today as regards this adjournment application. The committee is established to conduct a public inquiry in pursuit of its oversight function to hold the public protector to account. Thus, whilst it may have elements of a disciplinary process or even a court process, it is a sui generis process. And in fact, in the simplest of terms, this committee is the ultimate accountability mechanism. In that sense, it is incomparable to any other structures. The nature of the oversight, Chair, and the manner in which the process is conducted is circumscribed by two things, and that would be the overall process and the process of making this decision today. Firstly, procedural fairness is a standard made applicable by the Assembly rules to the conduct of the inquiry. In other words, the process must allow the PP an opportunity to have her side heard, and we've done so in the broader sense by giving her an audi before the commencement of the hearing, by allowing her to present her evidence when the time comes, and of course at the end of the process she's also going to be allowed an opportunity to look at the draft report and make her comments. In particular, in this application, she's been provided an opportunity to make written submissions and the oral submissions, which we heard this morning. Procedural fairness also, as Advocate Mpofu indicated earlier, requires that there be no bias. The nature of the latter requirement, I think we dealt with in sufficient detail in the last meeting, and I trust that members will decide on this application today with an open mind. Secondly, and importantly, is the standard of procedural rationality, and that's a standard for the validity of all exercises of public power, meaning that members must make any decision, including the decision on whether to grant this application today, in a rational manner. They must have lawfully sound reasons for the decision that they're going to take. The committee is now seized with this adjournment application, which it will need to adjudicate, as I've said, in this procedurally fair manner, and by allowing the PP to state a case, which has already been done, and making the decision in a manner that's not biased. And finally, by ensuring that the decision we make is a rational decision. In other words, it must be well reasoned, and there must be sound and defensible grounds for why the committee concludes in the way it will. However, Chair, whilst the committee is bound by the basic tenets of fairness, it is not required to conduct itself as a judicial authority. The requirements of fairness are flexible and context dependent. One cannot, as I've said, ignore the unique circumstances in which this committee operates. From a legal perspective, Chair, in short, it's my view that there's no legal impediment that prevents this committee from continuing its work in the absence of a court interdict or an order to that effect. The Constitutional Courts confirmed this in the Shwane versus AfriFauna matter, which is a 2016 matter. In that matter, Chair, the municipality was challenged in terms of its decision to remove street names. There, the court confirmed that there is no legal obligation on a body to cease discharging its functions merely because an affected person like the PP, in this case, would be initiating a legal challenge. That obligation can only arise if a competent court grants an interdict. Under the Constitution, this committee is duty-bound to discharge its function of determining whether the PP has misconducted itself and is incompetent as alleged. In that judgment, Justice Mocheng stated as follows: it needs to be stated categorically that no aspect of our law requires of any entity or person to desist from implementing an apparently lawful decision simply because an application that might even be dismissed has been launched to hopefully stall that implementation. Any decision to that effect lacks a sound jurisprudential basis and is not part of our law. It is a restraining order itself, as opposed to the sheer hope or fear of one being granted, that can in law restrain. To suggest otherwise reduces the actual grant of an interdict to a superfluity. For these reasons, there was no obligation on council to desist from removing all street names upon becoming aware that an urgent application for a restraining order had been filed. Only sheer choice or discretion, but certainly not any legal obligation or barrier, would lead to action being desisted from in anticipation of a successful challenge or application for an interdict. Advocate Mpofu, in his oral submissions and in the written submissions of the PP, placed reliance on the 2010 Picoli judgment. This is a judgment which is in essence in conflict with the constitutional judgment that I've just quoted from. There is in fact no risk of contempt of court, as there is no court order presently restraining proceedings. On the contrary, there's a constitutional obligation for this committee to deal with the motion that is before it. That being said, however, Chair, the committee must still consider the fact that the PP has indicated that she is proceeding with this review process and what the likelihood of success is in that process. As a successful process, because it would certainly then have an effect on the work of the committee going forward. Essentially, what the committee must determine is the risk of continuing vis-a-vis the risk that the court sets aside that recusal application. We may adjourn for an unspecified time and await the outcome of court processes. This speaks to that rationality component that I mentioned earlier. In this regard, Chair, I just want to make the following observations to assist members in reaching a rational decision on the matter. The recusal application was decided on after considered deliberation in this committee, informed by legal advice and a very thorough response from the Chair. I'm confident that the committee, in considering that application, complied with its duty to do so in a procedurally fair manner and arrived at a rational conclusion based on the submissions of the PP, weighed against the response of the Chair and Mr. Milam, which was not in any way in conflict with the independent view obtained from Council. On the issue of Mr. Milam in particular, Chair, it seems that we keep going back to this assertion that this is a motion of Ms. Mazzoni. This is not a motion of Ms. Mazzoni. In fact, Ms. Mazzoni has played no part whatsoever in these proceedings to date. I've been involved in these proceedings long before this committee began, and to the best of my recollection, the last time she's even received so much as an update was when the Speaker declared that the motion was in order. Other than that, she plays absolutely no role. Neither is it a motion of the DA. It is a motion of Parliament. Whilst the PP is of course at liberty to approach any court for any appropriate relief, such action on her part does not and in of itself cannot oblige this committee to seize its constitutional functions, nor does it relieve the committee of its constitutional obligation to hold her to account. The motion has been referred to the committee and it's now constitutionally bound to deal with it as per the mandate. It must do so as the Constitution requires, diligently and without delay, unless there are very compelling reasons to do otherwise. What is styled as an adjournment application is not a short-term request of a few days or even a few weeks to adjourn. It is a postponement granted. It is a postponement requested without a confirmed end date. It would be dependent on the judicial system, and there's no fixed date for resumption. I took note of what Advocate Mpofu said earlier today, that they are willing to only go up until the stage of the Western Cape High Court. But if history tells us anything, the Public Protector has repeatedly appealed matters. We've gone so far as to historically see the first of a rescission application. So I therefore don't place any confidence in what was said in that respect. The previous requests for us not to sit on particular days and so on have been granted, but it was granted with the understanding that we would make up the time. Some days by starting early at 9 a.m. and other times we've even built in Saturdays into the program. So I don't think that this particular adjournment application can be compared to previous occasions when the committee has agreed, or the chair rather has agreed to grant such. The committee cannot ignore the timeframes under which it's now operating. The fact of the matter is that the PP's term comes to an end in October of next year. It's a year from now. It would be reckless to allow, without solid reasons, for the process to be delayed until after this date, as it would mean that the NA may very likely fail in its obligation to hold the PP to account, simply based on legal threats or warnings, as it's so been called, which have been made since the very start of these proceedings. The knock-on effect, if we were to go to court, and where we are not where we do not have an end date, and there can be no commitment to an end date because the court is not beholden to this committee, would mean that this entire issue may become moot, because by the time the court makes a decision, whichever which way, the term of office may come to an end, and that the committee must bear in mind. We previously advised, and we reiterate again, that Parliament cannot and should not be paralyzed every time someone fails an application or threatens to do so. If that were the case, Parliament would never be able to fulfill its functions. That notion is as absurd as it is incredulous. That being said, a rational decision still requires that regard must be had to the merits and the prospects of success of that review of the recusal application. My view, which was supported by the external independent counsel opinion, was that many of the grounds raised in the recusal application were vague and failed to adequately express what the alleged bias, whether that was actual or perceived bias, was. The claims of bias were raised as early as day one, and we cannot ignore that the proceedings have been characterized by interruptions and objections, making an already difficult task all the more harder. In addition, Chair, much of the jurisprudence on which the PP now relies in her adjournment application relates to the standards of impartiality for a judge. And in our view, that reliance in support of the application is, for the reasons I stated earlier, misplaced. Essentially, whilst reliance is placed on the standards applicable to judges, the committee is not a court, and members are not judicial officers. The Constitution exclusively entrusts the Section 194 task to a committee of the National Assembly, a committee of publicly elected representatives that the drafters of the Constitution would have been well aware were not going to necessarily be lawyers. The cited case law establishes that if the PP is able to make out a case of bias, she may be able to convince a court to interfere in the committee's ongoing proceedings, either to interdict the committee from proceeding and or to set aside the committee's decisions in respect of the recusal application. However, the PP would still have to prove that case to the satisfaction of the High Court. She cannot obtain relief merely by alleging bias. Furthermore, the complexities of the separation of powers and the court's reluctance to interfere in the business of Parliament is not canvassed in that application. Parliament has the right to make its own rules and to run its processes as it sees fit, provided, as I've said, that we are confident that in so doing, we've done it fairly. The motivation places much reliance on the Pecoli judgment. That judgment, as I've said, is in conflict with a later judgment of the Constitutional Court, and therefore, in our views, entirely incorrect. With particular reference to these proceedings, the Constitutional, and when I say these proceedings, proceedings involving the PP that was taken to the Constitutional Court, when it considered the challenge to the rules for removal, it stated that the committee's proceedings should not be suspended in mid-air, because it's important for the PP to be held accountable in accordance with Section 194 of the Constitution before her term of office expires. Otherwise, and I quote, the administration of justice runs the risk of being brought into disrepute. The committee has, in my view, considered the PP's claims of unfairness within the applicable constitutional framework and found them to be without justification. It therefore follows that it may reasonably believe that the prospects of success of a recusal review is slim, and in light of its constitutional obligations, it must therefore continue with its process. The law, however, is not black and white. I know Advocate Mpofu said earlier that they are, if I'm not mistaken, 100% certain that their application is going to be successful. If that were the case, Chair, we would not be having this discussion. So whilst I'm not in a position to give that guarantee or to say that there are no prospects of success, I am certain that the process, regardless of the outcome, will be one in which Parliament can offer a rational and well-reasoned defense for the manner in which it has conducted the proceedings to date and for any decision not to grant an adjournment today. In fact, we've closely considered all the case law relied upon in the application, and as I've indicated, we believe that it's misplaced. And I take exception to the comment by Advocate Mpofu that's contained in the written application that the committee is making decisions without having thought them through and that they predetermined. If anything, the committee has been seeking legal advice, and much work goes on in the back room in order for us to give such advice. There are reams and reams of preparatory work that goes in, and what I say here is just a portion of that in order to summarize for the benefit of the committee. Conversely, though, Chair, my view is if the committee cannot rationally justify adjourning the proceedings today
in a matter of such national importance and in light of our constitutional obligations, given that the allegations of bias are in the view of the majority of this committee without merit, then we're going to find ourselves in legal difficulties. Further, the effect of such an adjournment may very well be, given the likely court timeframes, to result in a permanent cessation of the work of the committee, because there is no end date in sight. A judge could take 5 or 6 months to hand down a judgment, and the committee would be powerless to do anything, precisely because of the separation of powers. In any event, nothing stops the PP from bringing her interdict application on urgent grounds, and if successful, the committee will abide by such decision and pause its processes. I don't think that there's any question of that. If we were not to do that, then Chair, then we would certainly be in contempt. But to do so without being legally obliged under the current circumstances is a course that, as a legal advisor to the committee, I'd warn against. I, however, leave it to the committee to assess those risks and arrive at a decision that the committee bases on reasonable grounds. As an alternate, the committee may wish to offer them an opportunity to continue with the proceedings, but then agree that we expedite the court proceedings as far as is possible, bearing in mind that we are at the behest of what the court will allow as far as that is concerned, and the setting down of dates. From what I've heard this morning, though, Chair, it would seem unlikely that such an offer would be agreed to. If members want particular input on judgments that were referred to, we have in fact done that work, and we can speak to those judgments. But as I've said, we're fairly confident that they are misplaced. Thank you, Chair.
Thank you, Ms. Ibrahim, for that contribution to our work and the presentation from our legal services. That is meant, therefore, colleagues, before we get into our discussion as members, because I'm inviting you now to come in, and I'm very specific. This is the area of decision that you are getting in. I don't want us to be all over the place, so that you also are mindful of time. You would have listened from this morning. You would have read the application for postponement indefinitely. You would have listened to the oral presentations being made and the timelines presented about certain scenarios. You would have asked clarity questions. You've now just heard Ms. Fatima Ibrahim, on behalf of the legal services, as a way of, as we always do from the start of this, in the design and everything else, we've always had that important service. Thank you very much for always being available to walk the journey with us. It's a novel process. I always call it virgin territory, but that kind of guidance always would have made us walk this journey. I want to invite you, therefore, members, to make your contributions in mind that at the end of your contributions, there has to be a decision either way. Thank you. Honorable Mailam. Honorable Lagude. Honorable Denner, here today, normally runs away in the virtual. Honorable Heron from the virtual platform. Honorable Van Minen. Honorable Zongula. Honorable Olomisa. Honorable Nkosi. Honorable Malema. Honorable Mola. Honorable Gondwe. Honorable Nodada, in that order. Let's proceed. Sorry. Honorable Siwela. And Honorable Maneli. We start, Honorable Mailam, 11 minutes past 2.
Thank you, Chairperson, and let me express my thanks to Ms. Ibrahim as well, because I think she gave a very comprehensive advice to this committee. Chairperson, I want to start with the Pekoli quote that Advocate Mpofu opens his application with. And he's used this quote extensively to threaten this committee with contempt of court and members of this committee with contempt of court. Now, I think, first of all, that this is bad advice on the part of Advocate Mpofu. I think it's legally bad. In terms of the Constitution, in terms of Section 58(1)(b) of the Constitution, which reads as follows: Cabinet members, deputy ministers, and members of the National Assembly are not liable to civil or criminal proceedings, arrest, imprisonment, or damages for anything that they have said in, produced before, or submitted to the Assembly or any of its committees, or anything revealed as a result of anything that they have said in, produced before, or submitted to the Assembly or any of its committees. So right there we have the first immunity, if you will, of members of Parliament and members of the committee. And then if you go to the Powers, Privileges and Immunities of Parliament Act, it's right there in that legislation as well. In fact, that act goes further, and it suggests at Section 8(1) that a person may not, by fraud, intimidation, force, insult, or threat of any kind, or by the offer of or promise of any inducement or benefit of any kind, or by any other improper means, influence a member in the performance of the member's functions as a member, and it goes on. But my point is, Chair, is that the threat of contempt of court against members is, in fact, improper influence of members in terms of the Powers, Privileges and Immunities of Parliament Act. And I think it's scare tactics. I think it's, there's a lovely Afrikaans phrase, "Gogga maak vir baba bang." And that's exactly what this is. It's to muddy the waters and to make us feel threatened by what might happen to us as individuals. And I want to stress firstly that that is not correct. Chairperson, I want to pick up on something that Ms. Ibrahim said. She spoke about where the motion originated, and she spoke about the fact that well, let me not go there. Let me put it like this rather, that we are here as members of Parliament. Now, it would be an absurdity for us when this decision finally goes to the National Assembly, because the ultimate decision in the impeachment process of the Public Protector is not made here. What this committee is doing is it will make a recommendation to the House, to the National Assembly, who will then make a decision. And it would be an absurdity for any member of Parliament to be recused on the basis that they have an interest in the matter when it reaches the National Assembly. In fact, I cannot recall of a single instance in the last 28 years of democratic South Africa where a member of the National Assembly has recused himself from a decision in a sitting of the House. I might be wrong, but I can't recall any. So it would be an absurdity to expect members at this committee to recuse themselves, but not then recuse themselves from the National Assembly. And so I think there's a legal inconsistency in Advocate Mpofu's arguments. Chairperson, the one other thing that I just want to touch on is that we as a committee have no real decision to make apart from whether or not there are there is validity and credibility to the charges, and then to make a recommendation to the National Assembly. The decision is not made here, and therefore we can't be held accountable for any administrative action based on that decision. The decision is made at Parliament, at the National Assembly level, not at the committee level. And I think that we need to make sure that Advocate Mpofu understands that this is a recommendatory, an advisory committee, rather than a decision-making committee. Thank you, Chairperson.
Thank you, Honorable Mailam. Honorable Doris Lagude.
Thank you very much, Honorable Chairperson. Good afternoon, colleagues and the legal service, the legal unit reps who are here. Let me start, Chairperson, by thanking the legal opinion by Fatima Abrahams. We really appreciate it and we agree with it. Honorable Chairperson, from that legal opinion, I have isolated some few items which I want to emphasize. As we all know, Honorable Chair, I don't know where does this thing of saying is a motion of Mazoni and Mailam as the husband, whatever. So I don't want to entertain that. But what I want to say is that as this committee, we are dealing with a motion which was adopted by the National Assembly. And we have terms and references. And we are being guided by the rules of the House. Constitutionally, we have the mandate to do our work as Parliament. So nothing as of now is preventing us from doing that, unless we have a court order on our table, or that one, the court interdict. Then those are the two documents that will stop us from doing our work. Then as a committee, Honorable Chairperson, we have the directives that are also guiding us. We have been very patient. Our take as a committee, not as a particular party or individuals, is that we are on a fact-finding mission. Ours is to get to the bottom of this so that we can make informed recommendations and findings. As of now, we are not yet there where we are talking about removing or not removing anyone. And as a committee, we are looking forward to that day when the PP will take a stand and give us her side of the story. Because right now, since we started, what we've been doing, what we've been dealing with is the witnesses who came before us, who were giving us their evidence based on their affidavits. So by so doing, we haven't said that, okay, now that we have this evidence by the witnesses, then we have a concrete case against the PP. No, we are not yet there. We are not even near there. So what we are saying we are waiting for is the PP to submit her witnesses and for her to take the stand so that we can have her side of the story. That is Audi enough for her, as we've been guided by the legal services. So, Honorable Chairperson, there is this issue that kept on coming out from Advocate Mpofu, that we have hatred towards the PP. I don't know where that is coming from, because we have not questioned the PP of anything. What we have been doing as this committee, we've been questioning witnesses who came before based on the materials that they submitted to this committee. So that is what we've been doing. So that one is uncalled for, Honorable Chairperson. And this notion of saying that we are going to use our numbers to vote for what? Because there is nothing to vote for here. So as and when we get a court interdict or a court order, we'll stop doing our work. As of now, there is nothing. So as a committee, we'll proceed with our work. And we've been advised from day one to be impartial in this process. And that is what we've been trying to do all along. We have never insulted anyone. Ours is just to listen to what is presented before us, and we've been questioning those. So, Honorable Chairperson, we cannot abandon our responsibility based on the application that is brought before us today. We are not going to do that. We'll continue with our work. And as for the recusal of both yourself and Honorable Mailam, that one we have rejected as this committee. And as I'm sitting here, Honorable Chair, as a member of this committee, I'm saying I reject this application for the permanent adjournment or whatever. We will proceed as this committee until such time the court says otherwise. Thank you, Honorable Chair.
Thank you, Honorable Zagude. Honorable Danner.
Thank you, Chair. Chair, I agree with Honorable Tlakude. I think we as a committee have already set a precedent for this. You will remember in February of this year, the PP also wrote to the Speaker of Parliament to inform her that she was applying for a rescission of certain parts of the Concord judgment. And she also wanted us to postpone our work. And we decided then that we would not postpone, we would proceed. So I think we should look at that precedent that we have set. The same is true for now. We've been informed that there is an intention to approach the court for the review application. But the fact remains there is no order made by court. There's not even a court date, if I listen correctly. So I think we should stick to the precedent and proceed with our work. And I would like to thank Ms. Ibrahim and agree with her. We base our decisions in this committee on well-researched and very sound legal advice. So I would feel comfortable if we would proceed with our work. I think it's our constitutional duty, and I think we should go on with it. Thank you, Chair.
Thank you, Honorable Danner. Honorable Heron.
Thank you, House. Thank you, Chairperson. Chairperson, I think to start off with, we must be careful about an emotive response to the application and to taking exceptions to what's inside the application. I think it's a fact that the decision that was made that is now possibly the subject to review may have been made bona fide, but that doesn't necessarily mean that the decision was a lawful decision. The argument that this committee doesn't ultimately make a decision, I think we must be cautious of that argument. This committee is the only committee that is actually hearing the evidence and will hear the evidence being tested and will obviously make a recommendation to the National Assembly. But if the National Assembly was to disregard the committee that heard the evidence, the National Assembly's decision could actually be an irrational one, because on what basis could the National Assembly make a decision without actually having heard the evidence? So we're the ones that are hearing the evidence, and we bear the burden of making sure that this process is fair. None of us know whether a court will set aside the decision and sustain the review. And we haven't really heard any argument that in response to the application, other than a legal argument. But ultimately, the review application will be both a application on the facts that are presented and were presented in the previous application, as well as a legal argument. So, Chairperson, my proposal is that the legal team, and maybe yourself, whoever operates in the so-called back room, attempts to negotiate a process that allows the public protector to bring an application for review as soon as possible, and that allows for us to proceed as soon as possible with this process. And if that agreement cannot be achieved, that we reconvene and then decide whether to continue with the hearings regardless of the public protector's application. Thank you.
Thank you, Honorable Heron. Honorable Benedicta van Minen.
Thanks very much, Honourable Chair. And I really want to agree with Ms. Ibrahim. I think her argument was very cogent and I think it was very clear. Her points were well made. I really do think that at this particular point, we cannot afford to continually get stuck in sort of the trenches of constant legal applications. There is, as we've heard in the evidence, there is a whole series of these applications to do with various different things over time. This is a parliamentary committee. There is nothing that is currently stopping us proceeding. We need to do that. We have also unfortunately seen a tendency with the witnesses to threaten them with various contempt of court or whatever the case might be, perjury, things like that. And to now see those weapons directed towards the committee, I think is deeply, deeply unfortunate. I think we really do need to proceed. Time is moving on. We're now at the end of October. We know what the original timelines were. We cannot afford to essentially just engage in ongoing trench warfare where nothing moves forward and everyone is at an impasse all the time. That is not something that is carrying out our constitutional mandate at all. So I really do think we need to proceed. There is nothing stopping us proceeding. And as has already been said, the other side is more than welcome to go and actually get an interdict if they feel strongly about that. But at this particular point, the parliamentary committee must continue. Thank you.
Thank you, Honorable van Minen. Honorable Zungula. Honorable Zungula.
Thank you, Chairperson. Chair, I think it's important that sorry, wait, before I proceed, Chair, can you hear me?
We can hear you. Please continue.
Okay, yes. So this is a critical process, Chairperson, and the first of its kind in our democracy, where there's a fitness inquiry for a head of a Chapter 9 institution. Therefore, the work of the committee somewhat sets the precedent and sets the precedent for other future committees or committees that would have a similar mandate in future. Therefore, we must always be cognizant that whatever that we do as a committee here now today is critical for what would happen in future. Therefore, the issue of fairness becomes very important, that it must not appear as if there's a predetermined outcome and we are going to rush deadlines or we are going to push certain processes so that we are able to do our work within a certain particular time. Therefore, the issue of justice is also very critical, Chairperson, that there must be justice. And the process must not appear as if there's a witch hunt, and it must be an impartial process so that everyone that has trust in the Parliament of the people of South Africa knows that when Parliament is doing its work, it is not doing its work in favor of someone or against a particular individual. However, it is doing its work based on principle that could apply to the next person tomorrow or the next year. So in the nature of such processes, Chairperson, there will be disputes. Disputes are in the nature of such processes. So I would propose, Chairperson, that in light of what also Honorable Heron said, that we don't take an emotive decision. And we don't take a decision, this committee does not take a decision because it wants to proceed hastily, or it has a particular timeline or timeframes in which it wants to reach certain outcomes. So I would suggest that we halt the proceedings, because also in the court proceedings, we are not sure how, the judgments, no one knows what the judgments would be. There could be a judgment that would come up and say, you know, the chairperson was wrong for not allowing for a recusal to take place. Now, what then must happen once that is a determination? Will it mean that everything that has been done, all of the monies that would have been spent, all of the time that would have been spent, you know, they become wasteful expenditure? So that is why I support the adjournment. And if it happens that, you know, the majority in this committee feel otherwise, maybe the next best thing to do is to get an independent legal opinion, not a legal opinion that is based on someone that is intricately involved in the running and the operations of the committee, because obviously they will take a particular direction. However, an independent legal opinion will afford the committee to have an opinion that is, you know, that is independent, that is not, you know, conflated with a lot of information or issues regarding the work of the committee. And lastly, Chairperson, I would also, you know, raise the issue that regardless what happens, whether the National Assembly will make a determination, however, the National Assembly is determined on the report that will be issued or report that will be tabled by this committee, a report that will be prepared by this committee. Therefore, would not want to have a report that is tainted by court proceedings, tainted by issues of lack of fairness from the side of the chairperson, court proceedings that have a lot of back and forth. Therefore, I want to end off on that note, Chairperson. Thank you.
Thank you, Honorable Zungula, for your contribution. Honorable Olamisa.
Hello? Hello, Chairperson?
You have the platform, Honorable Olamisa, we can hear you.
Thank you, sir. Thank you, thank you. Mine would be to encourage you and the evidence leader, as suggested by Advocate Mpofu, that you could perhaps meet and avoid this long litigation process. Try and find each other. But in the event that you are not prepared to entertain that or position of or suggestion of Advocate Mpofu, I would strongly suggest that we may have to seek a legal opinion as well. I don't have full confidence, I must confess, and I won cases against legal advisors of Parliament who have lost many cases. So I always like us to get an independent opinion from outside. But if the members of the committee, the majority members of the committee feel that let Advocate Mpofu and PP advance to challenge this in court, I would say a request from this committee that in the meantime, Advocate Mpofu, as well as the evidence leader, can they share us or highlight in the reports some of the disgruntled witnesses who were subjected to disciplinary hearings by the public protector? I'm referring now to those who said some of their evidence was tampered with. Who drafted this evidence and try and mislead or misrepresent those witnesses? So if during this period you are going to court Advocate Mpofu as well as evidence leader, please share with us all those documents, or rather not documents, but highlight those witnesses who claimed that their evidence were tampered with by the evidence leaders. Thank you.
Thank you, Honorable Olamisa, for your contribution. Honorable Bekizwe Nkosi.
Thank you, Chairperson. I Chair, welcome the fact that the Speaker has said that this committee and only this committee can and should take decisions on this matter. So this matter lies squarely within ourselves. Secondly, Chair, I think that, and I'm comfortable that we are exercising our constitutional duty on oversight, and in doing so are guided by our own rules as the committee, but also by the rules of the legislature, which is the National Assembly. And these require us to be fair, impartial, and at all times to allow processes to exhaust themselves objectively. I move from the standpoint here that one, we have got time frames. And in terms of the directives, we must complete this process within a reasonable time period, or within a reasonable time as directed by our own directives. And in view of the fact that, which has been alluded to, that the PP's term of office will come to an end next year, I think that being engaged in protracted legal processes may overrun us and the process. And I agree with the advisors that if we accede to such, we may seem, or we may be neglecting our constitutional responsibility to exercise oversight. And that, for me, is an overriding motivation. The other issue, Chair, is that I've listened to Advocate Bofu and the cases cited and the standards outlined by him. I tend to think that the standards are as applicable to judicial officers sitting as judges, and these are much higher than standards required of chairpersons of tribunals. While they may be the same, they're not entirely speaking to each other. So it may be important that when we take decisions, we remind ourselves that we do not sit here as judges. We do not sit here as legal practitioners or experienced people or law experts. We're sitting here as members who are required to take decisions on the basis of rules of the legislature, which is the National Assembly and this committee. Chair, I've said in the past that we're engaging in a process where the public protector is sitting on the steps of the Western Cape High Court. Anything that we do, she will knock on that door. So the continual threat of taking legal action against us should not impede us from taking decisions for fear of being taken to court. If we are able to demonstrate that we are exercising our inherent powers and responsibilities, and we do so in an objective, fair, and open and transparent manner, I don't think that there's any court that is going to fault us on that in any way. If you were to, let's say, we were to accede and we were to get a different chairperson, there's no guarantee that that chairperson themselves will not be subjected to a similar process, which may add another 6 years to this process. So my suggestion, Chair, is that we proceed with the process, reject the application for adjournment by the PP, and build into that a process that allows you as a chairperson to engage with the PP team to ensure that there's objectivity in this process.
Thank you, Honorable Ngosi. Are you done?
Oh, thanks, Chairperson,
You
I'm
have a
done.
problem towards your end.
Yeah.
Are you done? You frozen. You're cutting. We can't hear you. Okay. Thank you, Honorable Ngosi. If you're done, ask the secretary to check. I'm now going to recognize Honorable Malema to the platform.
Yes, Chairperson, I'm done.
Okay, thank
Can
you,
you hear me now,
Honorable
Chair?
Ngosi. Thank you, Honorable Malema.
No, thanks. Thank you very much, Chairperson. I think that firstly I don't know, you said the Parliament legal advisors and all of that. She keeps on saying, this is not a DA motion, this is a Parliament motion and trying to sound technical and smart in favor of perhaps a preferred party. We may not know. But this is not a court of law. It's a parliamentary process and it's constituted by politics. So don't come here with your neutrality, pretentious neutrality, and create an impression that there are no politics behind that which we are dealing with here. There's nothing called parliament motion. No parliament sponsors any motion. It's political parties, it's members of parliament who sponsors motions, and then they become parliament resolutions. So your reputation of this becoming parliament motion shows your biasness and your interest to see this matter through in favor of a certain political party that has sponsored this motion. It doesn't matter how many times you repeat it. It is a DA motion, and get it in your head. It's a DA motion sponsored by a wife of one of the members of the committee here. And it's a fact, it's your wife. Whether you are turning, whether you are sleeping, whether you are facing up, it's your wife that presented the motion in Parliament. It's a fact. Whether you are conflicted or not, it's something that we can debate about it. But the fact of the matter is, your wife has sponsored this motion, and that's why you are vividly participating in it, because perhaps it's even part of the pillow talk, this motion. I don't know. But your eagerness and your uncontrollable interest in this matter as an honorable member, it shows that it goes beyond an innocent member of parliament, but a partner who's vividly participating in a motion that was sponsored by the wife. And you want to make sure that this motion is seen through in the best interest of your wife and enhancing her capacity and her image in society. So those are facts, whether you like them or not, it's a reality. So whether you must recuse yourself or not, it's not a committee resolution. It's a personal conscience that you and the chair have actually responded to. Now that we are being taken to court, Chair, it is now upon us as members of parliament to now, as members of this committee, to now on our own seek legal advice on how do we navigate this, because I've got no confidence in your legal advisors and that legal parliament department, because it is partisan and biased itself. So I will ask that we adjourn this matter and you allow us time to go and consult our own legal teams as well, as you continue yourself to explore a possible way out of this through the engagement with Public Protector's legal team. A very persuasive and comprehensive matter has been presented here, and case law has been referred to, different cases are being referred to. As a layman standing here, I can't confidently say, like others have said, let's dismiss this matter. I've got no such qualifications. I don't have such qualifications to can confidently, without consulting my legal experts on how do we get out of this one, say no, let's dismiss it. If we don't carry partisan mandates that have already concluded to guillotine the public protector, we cannot object to the fact that a very comprehensive document has been presented before us by the legal team of the public protector. Give us an opportunity to go and make legal consultation, and so that we can give a more informed input with regard to this matter. A new matter has been raised, Chair, that we will be in contempt of court if we proceed with this matter. I heard the honorable husband of the person who sponsored the motion saying we can't be intimidated and all of that. I'm not going to allow that. I'm not going to be arrested here. Zuma has been arrested for 15 months for contempt of court. And I must be told by people who are conflicted, who are accused of bias, who are accused of having uncontrollable interest on this matter, that I must proceed with this matter without consulting my legal experts, my legal team, even when I'm told that there is a possibility of me being arrested. In this country, anything is possible. An 8-year-old man was sent to prison for 15 months for contempt of court. And a senior counsel comes here and says, if you guys proceed ignoring what we're telling you, you will be in contempt of court and you'll go to jail for a very long time. And I must trust the parliament legal advisors, the biased legal advisors of parliament, who have lost so many cases. It's not only General Olomisa who has lost cases, who has won against them. We have won against them many times because of their incompetency. So I'm not going to take that incompetent legal advice as the true reflection of what is going to happen. We're asking as the EFF that we be given an opportunity to consult on this matter, our legal experts, before we can continue to participate in this, because we don't want to be arrested. Thank you.
Thank you, Honorable Malema. I note you, I'll come back to you. I now recognize Honorable Palangola. Honorable Palangola. He's not there. We'll come back. Honorable Gondwe.
Chairperson. Chairperson, let me start by appreciating the legal advice from Advocate Ibrahim, and allow me to use this opportunity to thank the Head of Legal Services, Advocate Enquiry, and the rest of the team for supporting us throughout these proceedings. Their support has really, enabled us to get this far. Chair, I also agree with the advice from Advocate Ibrahim that in the absence of a court order or an interdict, no one and nothing should prevent us from carrying on with the business of this committee, not even the threat of arrest or of being found in contempt of court. Look, Advocate Mkhwebane will be well within her rights should she decide to proceed with this review of our proceedings. She's entitled to do so, but until such a time a court says we must stop, let's carry on. We are operating under very tight time frames, given that we recently took a break between considering some of the recusal applications. And should we accede to this adjournment application, we would be failing in our duties and our responsibility as a committee to hold Advocate Mkhwebane accountable before her term ends in October. And if we agree to this adjournment, we might as well wrap up our business as Parliament, because we wouldn't have enough time to proceed with the business that remains. And Chairperson, contrary to what Advocate Mpofu has indicated, that the PP is more than ready to tell her side of the story, I'm not convinced that's true. We've sat through 3 recusal applications, including this adjournment application. And for me, all of these applications points to someone who's not ready to have her side of the story told. And we are sitting here and we are ready to hear her side of the story, but she doesn't want us to hear her side of the story. And Advocate Mpofu indicated that they had submitted a list of witnesses in August. And as far as I can recall, that was a provisional list, as some of the witnesses had not confirmed their attendance. So I'm not entirely sure what's going on. Let us get on with the business of this committee. Let us proceed. Let us reject this adjournment application. It has no merits, it has no grounds, and get on with the business of the committee. We don't want to be found failing in our responsibility. We've been charged by Parliament to ensure that we make a recommendation to the NA after gathering all the facts. And we need to gather all the facts, including her side of the story. We are willing and we are able. So through you, Chairperson, please let's carry on. We've sat through 3 recusal applications and now this adjournment application. I think it's time to move on. We are waiting for us to to conclude with the cross-examination of Ms. Thejane, and we are waiting to hear from Mr. van der Merwe, who's the last witness from the evidence leader's side. And we are looking forward to her team leading witnesses and her ventilating her side of the story before this committee and before everybody that watches these proceedings. Thank you very much.
Thank you. Honorable Gondwe, for your contribution. Honorable Sukas.
Thank you, Chair. Chair, a lot of what I am going to say, I think has already been said, maybe in some form, just in a different way by members. But I think the first thing that I just want to highlight is our constitutional obligation that has been spoken of by several members. And to what extent does the current delays and challenges impede us to perform that duty? That is a consideration that we as a committee must take very seriously. Our obligation as parliamentarians and our duty in that regard. Because, Chair, we can become delinquent in the delay of our duty, and I think that is an important point for us to consider. The public protector, it must be said, and I have said it before, Chair, and I think a few people have said it before, not today, but previously. The public protector has a very competent legal representative sitting here with her, and that is providing her with support and defending her and making sure that she, defend is the wrong word, but making sure that she is being treated fairly. She has a right to a review. So the rights of the public protector is being protected here. The process, however, for us as members of Parliament is one that we need to fulfill our obligations, as has been said here. And I think that is the biggest concern right now, is the issue of how does these delays hamstring Parliament, hamstring us as a committee, and stops us from performing our work. That is the consideration. The constitutional rights of the public protector has been considered. It is being protected, as I've said. And the function of the committee as an oversight body cannot be disregarded by any one of us who was sworn an oath to perform our duties. So any other delays now brings us to the point which was in the beginning of the process, spoken of by Honorable Mulder and also by Honorable Hendricks, where it becomes such a drawn out process that already now we are going way beyond what any other process has previously been embarked on. So, Chair, I just want to highlight that the length and the duration, and I want to ask, I asked it previously, if the cost, the legal cost of the public protector can please be shared with us as well, in part to do with our role as oversight, because as I'm speaking to you, I have a constituency that is currently unable to go to court because they don't have money. They're so poor, they're somewhere there in the Karoo, and they just, you know, and here we are sitting and it seems as if, you know, we have a, the issue of cost is a big issue. Normal South African doesn't have this privilege. So for me, I want to highlight that, Chair, and just say that we need to continue, we must continue. And we must assert the rules of Parliament, and we've got the rules of Parliament and we've got the directives. Those are the things that are guarding this process. So we must proceed.
You done?
Sorry, Chair, I switched it off. I said thank you, Chair. Yes,
Thank you. Okay. Thank you, Honorable Sukas. Honorable Siwela.
Thank you, Chairperson. Thanks for the opportunity. Greetings to everyone. Chair, I have listened to Advocate Mpofo's presentation as well as Fatim Abrams. What I would like to indicate, Chair, and consistently I'm saying this, that we must give the PP opportunity to present herself because there is no one who has been found guilty up to so far, and we can't preempt our outcome. I'm sorry, we can't preempt our outcome, Chair, before we have dealt with this process fairly so. So my humble appeal is that let's stick to the rules of the House. Let's continue with the process. If ever there is anything which will come to us to prevent us moving forward legally, is then that we're going to observe that. But for now, to delay this process, we're not even doing justice to the PP herself. So my humble appeal is that we proceed with the process, and so that at the end of the day, we are able to consolidate and recommend to the National Assembly, because as the committee, we're not going to take any decision. The decision is going to be taken by the House. So my humble appeal is that we proceed with the process. I want to support those who are saying, let's reject the application and move forward. Thank you, Chair.
Thank you, Honorable Swellen. I now recognize Honorable Mautwe.
Thank you very much, Chair. Chair, I'm 100% covered by Honorable the President of the EFF, Honorable Julius Malema. But I just want to bring one issue to your attention, Chair, that is disturbing me sitting here. You called on the legal person from Parliament to speak, and she spoke in the absence of the PP and her team, her legal team. And even worse, of course, she was going to criticize the application brought by the PP, but even worse, Chair, you do this after lunch when we are now expected as committee members to make our inputs and comments. So to me, it appears like you are trying to hypnotize us, because what we remember is the last speaker who spoke before we came in. So you make the application of the PP to be erased from our memory and only to
think about this biased legal person from parliament. It's wrong. I don't think you should do that because firstly, the PP does not have a right of reply on the things that she has said. And now secondly, members who are engaging, but before we engage, we get told that no, this is how we should perceive this application. I think it's wrong, Chair. Thank you. Just correct that, Chair, and let's run this process fairly for everybody. Please. Thank you.
Thank you, Honorable Maute. The next speaker that I'll recognize is Honorable Nemadzinga Chabalala.
Honorable Chairperson, good afternoon to honorable members. Firstly, Chair, one would have listened attentively to what has been presented in the morning, rather. And when we started this meeting, and I want to declare perhaps in advance that one does not have any memory erasal whatsoever. Now, the matter of the legal persons from Parliament, isn't it? This is a Parliament inquiry, it's a Parliament process. So, and they've been presenting, especially when we've got closed meetings. So I don't understand where does that one come from, but nonetheless, we are here now. So we are more than happy with the legal opinion of Parliament that has a mandate to really take us through as the committee and advise us accordingly. Now, Chair, the matters, and I want to state it perhaps in advance that categorically clear that sitting as a member of Parliament, but also a member of the ANC, that firstly, that one rejects this adjournment that has been brought to our shores, and yeah, that's first part. Let me just put a bit of context into where we are. Chair, if you check into the our role and how we've been constituted, we are constituted to ensure that we proceed with these matters and we're able to report to Parliament. Now, anything else that seeks to perhaps derail the work of this inquiry, if not of this committee, we should be able to scrutinize fairly so. And I want to also state that it's important for us to ensure that, I mean, the PP matters that treat us with utmost fairness whatsoever. And this notion that keeps on popping up that says that perhaps we've got predetermined objectives or issues whatsoever, and we want to take it out of the window. I think that it has been a long time coming. It's really unbecoming, honestly speaking, if not condescending to ourselves, having had to sit here many times and many days, resources and times that were coming here, and we're not wasting it because we understood the functions that has been bestowed upon us. Now, if you look, Chair, in the matter in Schutte versus Van der Berg and others in court, that would have said in an open court, in proceedings like in any inquiry, in balancing the interests of the individual, it will often be inappropriate to insist upon the ground of a remedy developed for and suited for judicial type proceedings, a close quote. The adjournment, therefore, application is sought by the PP as a consequence of the refusal of recusal by the chairperson based on judicial type justifications and or grounds advanced. And as a provided for above, there are no judicial proceedings here, and that has been very clear. And I would like to think that colleagues understood that that is not a judicial proceedings. It will therefore be wholly inappropriate, Chair, for the committee to grant the application for adjournment. The grounds for adjournment as set out in the application, therefore, stands to fail from where I'm seated. In fact, this recusal application is brought in the middle of the inquiry, that's one. And when the inquiry is about to conclude its first phase of witnesses, wherein the PP participated and challenged this evidence. And just before the PP presents the evidence under the circumstances constitute a disruption of the proceedings, and that's where I'm seated. And I think this is disruption of this proceedings, and I'm quoting in terms of the Rule 129AD subsection 2 of the National Assembly rules. The committee must conclude its work, Chair, within a reasonable time frame. The committee has a constitutional responsibility of ensuring the inquiry is not unduly delayed. That's also a third point, which seems to be the approach adopted by the public protector, and that's my view. Anybody can challenge that. And from where I'm seated in terms of the judicial review, Chair, the PP submits that there are pending judicial proceedings to review the decision of the chairperson and Mr. Milham. And this is yet another misrepresentation, if you ask me. The matter is not currently before the Western Cape High Court or any other court whatsoever. Even if there was, chairperson, such a pending matter before the court, it will not have prevented this committee from continuing with its work unless the PP interdicts the committee from continuing with its work. And in succeeding with such an interdict, chairperson, the PP will have to prove that there are prospects of success of the main review application. In the absence of such, chairperson, of an interdict from the PP, there is no legal basis for the committee to adjourn its business and its proceedings. So we want to move with the process, chairperson. We're very ready to conclude and see that we carry the mandate that the parliament has bestowed upon ourselves. No delaying tactics should be entertained at this point. Thank you, Chair.
Thank you, Honorable Namadzinga Chabalala. Honorable Nodada.
Thank you so much, Chair. Good afternoon to everyone. Chair, am I audible before I continue?
We can hear you. Thank you.
Thank you so much, Chair. Chair, first and foremost, we've read the application that has been presented to us today. We've listened to it being orally presented to us. And the aim for this application is on three things. To review, one, the recusal application that has been put forward the decision that has been put forward by yourself and Honorable Milham not to recuse yourselves. Secondly, it was also part of the review, the decision that was taken by the committee based on legal advice to accept the fact that you've exercised your rights and Honorable Milham has exercised his rights not to recuse themselves. And then thirdly, it then is indicated that part and parcel of this review, based on the two above, we must then adjourn and then negotiate with the legal team of public protector and so on. Now, Chairperson, we've got a legal and constitutional responsibility. That is why we're elected members of parliament who serve as legislators. And I continuously repeat this because we need to understand our role and responsibility. And upon the legal services advice, the legal opinions that have been sought, at this point in time, having read what is being on the application, having listened to the oral submissions, having listened to the legal comments by the legal department of parliament, and obviously having sought legal advice ourselves, is that there's nothing that is legally stopping us from continuing as a committee at this point in time. And the reason why I say that is that part and parcel of our constitutional responsibility as elected legislators is that we are in this committee to exercise a particular function that we've been elected to do. By the way, we were bound by the Constitution to go for. And having had nothing that is legally stopping us from continuing with this process, I see no reason to do so. Now, coming to what is being put to us to consider the adjournment of the committee with various threats that have been put on the table, as if we don't understand the law as legislators, that you'll be in contempt of court. What contempt of court? Which contempt of court? and that we will be arrested for some, sort of contempt of court, which is nowhere to be found. And I think sometimes we need to kind of call out these things of people illegally threatening legislators if we know nothing about the law. Now, with the point of us considering the adjournment of the committee, based on the very same facts that were put to us around recusal, which, by the way, we all, as committee members, made our inputs, and the vast majority of the members of the committee, based on their inputs, had factually, through legal advice and opinion, rejected the merits that were put on that from a factual point of view and a legal point of view in any case. Now we must adjourn based on the very same facts that are being sought upon us to accept the fact that there's a review on this recusal application that was put forward on your behalf as chairperson and Honorable Malam, which, by the way, we had personally, as a member of this committee, had rejected in any case because, one, factually, they were not correct. Number two, legally, the advice that has been sought has taken us to a direction whereby we will to accept you exercising those rights to do so. So I see no reason why we need to be able to now, at this point in time, having made a decision based on our inputs, based on the legal advice that we got, that now we must backtrack and say, no, fine, let's adjourn and then we go and negotiate. The public protector has every single right to exercise the legal routes that are available to her and exercise her rights that are available to her based on whatever perception she has determined on whether you are biased or Honorable Milam is not supposed to sit here, or whoever else, whether the cat runs out of the room and whether it's unfair or not. It's up to her. She can exercise those rights. But we are more than willing, since we've said in day one, to listen to all sides of the story in a fair manner to achieve justice at the end of the day, because there is no fair process that does not have a timeline. And it seems as if now fairness, is unlimited time. There's no such thing as fairness being unlimited time. Fairness comes with the responsibility of ensuring that there's reasonable time put on place to exercise that particular fairness to ensure that there's a just outcome at the end of the day. Now, Parliament 101, Chairperson, is that once a motion is adopted by the House, it becomes a Parliament motion. The Chief Whip of the majority party can stand up and say, we nominate Honorable J.S. Malema to go and serve in the Pan-African Parliament. That motion, once it's adopted by the House, it's a motion of Parliament, and therefore when that information is sent to the Pan-African Parliament, it becomes communication from Parliament. It doesn't become a motion of the Chief Whip of the majority party. So it's very important for us to understand the facts, and as legislators and members of Parliament that have a responsibility to understand how the House functions, what the constitutional obligations are, and what the legal requirements are of us to exercise our duties is very, very important. Now, the last point, Chair, I would like to make is that this particular application that is put forward to us requires us to look at what has, because we can't just make decisions arbitrarily. What advice have we received on the 3 different occasions when these things came to us? What decisions were made based on what facts, based on what legal advice, based on what opinion that was been put there legally, so not based on emotions, and what decision was then taken. Now, when we adjourn or when we say, oh, it's fine, we'll accept this application for adjournment, it means those decisions that we've taken on 3 different occasions, we now accede that they are questionable. Now, Chairperson, I do not believe that the decisions that we've taken are questionable because we have sought legal advice, we've thoroughly gone through them, and we've made a decision based on the facts. And it's important for us to understand that there's a process that has taken place prior to this. And once we take a decision now to say, look, we'll accede to the adjournment and take an engagement and discussion, it means those decisions then become questionable. The public protector can exercise all the rights that are available to her, and she must, she has every single right to do that. I do advise now, Chairperson, based on the decisions that we've taken in the past, the legal advice that we've received in the past, including the legal advice that we're receiving now, that Parliament can be able to put reasonable facts and supported with constitutional and legal prescripts to be able to rationalize as to how do we get to this point in time as a committee, and why did we take specific decisions based on whatever factual and legal reasons there have been. So we need to proceed, and the public protector has every single right to go exercise their duties. And I think Honorable Conway put it clear that we are more than keen to listen to the side of the story of the public protector. But from a layman point of view, from somebody sitting from outside, having a perception or perspective of what's going on in this committee, could reasonably conclude that she may not want to exercise that right. And these different applications to delay the process up until a term of office may end. It might as well not be the case. And that is exactly why we would like to afford a reasonable, fair time for the public protector to present a case, so that this committee can consider all the facts before making a determination and recommendation to the House in the National Assembly. So I think, Chairperson, let's do proceed. Let the public protector exercise their rights, and then we'll take it from there as a committee. At the end of the day, whether it's an urgent application, whether it's a review application, there has to be proof that there's urgency for that to be taken place, and the facts must be placed on the table. And I think we'll take it from there once that has been done. Thank you so much, Chair.
Thank you, Honorable Nodada. Honorable Maneli.
No, thank you, Honorable Chair. Greetings to honorable members and the Parliament legal team present here. Maybe just a few points, Chair. Firstly is to note the submission made by the legal team of...
Just a pause, Honorable Maneli. I see a second hand, Honorable Malema. Is that a point of order?
No, I'm queuing. I'm on a Shosholoza train waiting to take my next bite.
Oh, okay. Thank you, Honorable Malema. Be safe in that train. Honorable Maneli.
Thank you, Honorable Chair. As I greeted honorable members, I just said, Chair, the first point to raise for me is to note that there's been a submission made by the legal team of the PP on behalf of the PP. And for that reason, we have an item to discuss. So having noted that, Chair, I also note from the submission, when one looks at 10 and 15 read together, that were presented with a situation, in my view, where it's either you agree with me or I'm already in court 60%. So in essence, you do not give the committee an opportunity to make a proper reflection other than to give it two options. Agree with me. If you disagree, I'm 60% in court. Which I think there's not been any further justification you can give to what has been presented before us, Chair. I also want, Chair, to note and accept the presentation made by our legal team, Mrs. Abrams. But more importantly, I note the reminder from a point of recency that whilst we may have case laws that are quoted, there's a recent constitutional court decision which paves the way for this committee to proceed with speed. It doesn't just say proceed, but with speed, understanding the importance of this matter that we are dealing with. Therefore, if we do not move with speed, if there's any contempt, in my view, will be the contempt in terms of what the Constitutional Court has said we should do. And that's the one I'll be worried to be in contempt of. Because the other one is still an intention to go to court, which the document itself does say, I may not go there in case you resolve my way. And I can't make decisions based on that. That I can change my view depending on what comes. When there's a standing matter of a court decision that says proceed, but proceed with speed. And if you don't do that, that's a travesty of justice. Now, and I want to contextualize the justice as I understand the role of the public protector. Like Advocate Mpofu has repeatedly reminded us in this committee, that the public protector is not really about sitting here, but in the main, it's about protecting the public. Dragging the matter further, we will also be complicit to that of keeping the public protector in this process, instead of ensuring that there's stability in that office and that the public, for what the public protector has been put for in terms of the Constitution, is protected. And I would not want to be again part of such a contempt, Chair, because then it would mean I'm also working against the Constitution, when the Constitution made provision for these other Chapter 9 institutions to further ensure that the public is protected even from abuse by those that are in power. And this is the drilling we've been given throughout this hearing. We just need to have it in practice, I think, both sides. Chair. Having made that point, therefore, as I said, I accept this. And I think for me, consistent, what Honorable Malema raised in the presence of Advocate Mpofu as a form of question was that as parliamentarians would have said, we can't deal with this matter if it was before court. And now that it is not before court, how would you get to that point of contempt? And I think that's a consistent question, what we need to be dealing with. And that question could not be answered except to repeat that there's an intention to go to court. But I'm still arguing, Chair, that there is a court decision for us to proceed when we stopped at that time. So that court decision paved the way to be where we are today. And therefore, I agree with those that are saying then as a decision, having noted all this, as a decision that we proceed, Chair. But in that point of proceeding, I want to suggest that that's where we can get your back office to be doing the work, working with the PP side. And by that, I mean, I think having a decision today and expect that the PP will swing into action tomorrow may also be seen to be just about pursuing the PP instead of pursuing justice. And that's why I'm talking to this back office doing work. In doing that work, you should be able to put that proceeding means that we have to get the remaining witnesses, whether the other one was just about getting cross examination and the other one was going to start, and that prepare along those lines, so that at least it's still put before the PP and the team for them to elect whether they would want to still do cross-examination or not, because in any event on record, there are witnesses that appeared before the committee, and they would elect that we may not even want to ask or cross-examine these witnesses because we do not believe there's anything except to clarify one or two questions that I want to clarify. But that's how they would elect to go. in that score, you would not be really compelling them to do it. So I'm saying, Chair, that's what probably would need to do as a way of moving forward that we are now continuing. The second point I want to raise for consideration is that there is a 2 weeks that was agreed upon. Include all that in the way forward on operationalizing a decision to proceed. That with the confirmation to the question asked by Honorable Gondwe that there are witnesses in place, but there may have been issues that happened, whether by publication or whatever, but give again space to the PP to check if the PP elects to bring in witnesses, because I also want to stress the point that necessarily the person to account is the PP. The witnesses may be about, of course, concretizing a point that she would want to bring to the committee in defending or rejecting whatever has been put before the committee thus far. So I thought it's important that we remind ourselves that the inquiry is about the PP in the main. Yes, there may have been provision that the legal would be representing the PP, but it is not Advocate Mpofu who is before the committee, but Advocate Mpofu advises his client, the PP, and then speaking in that regard on her brief. So I'm just saying, Chair, we may need to look at that. And I think, in my view, it is still about ensuring that within reasonable time, the PP is also afforded an opportunity, whilst everything fresh in the mind, to be able to give a side of the story, and that we can make also informed decisions, right? Because when you take many gaps in between, you'll end up being in a situation where you are not sure whether you are dealing with an adjournment or you are dealing with the revival of the recusal application. So I don't want us to get to that, Chair. So that's really my submission, Chair, as we move forward, so that at least if you are to take that break, even the intention will become clearer if it was a genuine intention of the 31st of October, that you'll still have that if there's no reason to proceed. But it may be that out of that engagement, there will be a bit of common ground that at the end, this is not about pursuing the PP, but pursuing justice. And there's a constitutional court decision that says, do it within time, which is an agreement with the mandate given to us by Parliament. And I'll reserve my comments on other matters of criminality because they still do not exist as we speak. Thank you.
Thank you, Honorable Manedi. The last hand that got lost, Honorable Nwala.
Thank you very much, Chair, and apologies. My system's collapsed here and ICT department is not assisting me. Chair, I'll just say this, that I'm in support of the general view that the inquiry must proceed and the application be dismissed. And I equally share the same sentiments that it is quite misleading that just by an intention to go to court, then if the committee proceeds, it will therefore be in contempt of court. So, Chair, I support that the committee must proceed with the inquiry. That's the view that I'm supporting. Thank you very much, Chair.
Thank you, Honorable Paul Angola. It helped that you had this network that made you to be very short. So we must get this network every day. Thank you to the network. Honorable members, that would have been the last hand that I would have noted. from the members. I want to proceed, and before I do the summary and of your inputs and the decision, today I want to make my own separate comments in addition to what all other members have said. But there are two things. There's and I'll give Temungosi to read that. But there's also still, your hand is up, Honorable Malema.
Yes. Should I proceed, Chair?
To leave you out.
Should I proceed, Chair?
Yes.
No, Chair. I wanted to say, you can make your summary, it's fine, but it is actually disingenuous for members to say we have ruled on this matter of recusal before, and therefore we can't be entertaining, because this is a completely different matter. This is a matter that deals with a review of the refusal to recuse yourself. So it can't be that, no, we've dealt with it before and then the same approach should take place. It's wrong. And then the second issue is that Honorable Mpilo Maotwe, she's correct. The legal advisor can't speak after you have asked those colleagues to leave the room, because they don't have the right of reply. But also its intention, as I look at it, was to try and influence us. So Honorable Mpilo shouldn't be worried about people who say their memories won't be erased, because they've got no memories and brains of their own. That's why nothing will not be erased. You can only erase where there is brain or memory. In the absence of such, there is nothing to be erased. So the intention was to influence us. And I think that the way you've staggered it was very problematic. But the last point we want to make as an EFF, the last submission we want to make is that we have asked that we adjourn so that we can get a legal opinion. That is separate from what Honorable, Advocate Mpofu said. The EFF is asking that we want to make consultation on the basis of the presentation made, which contains possible arrests for contempt of court, and we don't want to find ourselves in that situation. And we're asking that we adjourn this, because we really cannot proceed with participating in this committee if there is such serious matters of concern that have been raised with us, and we're being coerced by the majority to participate in illegal activities. If you insist that you're going to proceed, even when we ask you for an adjournment to make our own consultation, we'll be left with no option but to pull out of this committee and not continue with participation. It will not be for the first time. We refuse to participate, if you don't know, in the Nkandla committee, when the majority of you participated and proceeded with it, and later for the court to tell you you are absolutely wrong. So it will not be for the first time. You can use your majority to insist that we proceed, but we are politely asking you as colleagues to give us time to go and make consultations with our legal team, because we have no full confidence in your legal advisors who were positioned to influence us in our deliberations. Thanks.
Thank you, Honorable Malema. Is that a point of order, Honorable Tlawude?
Thank you, Honorable Chairperson. I raised my hand earlier, but as members were making their own inputs, then I put it down. Honorable Chairperson, I want to caution us as members of Parliament that irrespective of whether we are happy or not with the legal opinion that we are getting from Parliamentary Legal Services, there is no need for us to insult them. They are parliamentary officials. They are not like us as members of Parliament who can respond when there is something that we are uncomfortable about. So there is no need for us, if we are not happy with their work, there are processes to be followed. There are presiding officers in this Parliament. then we can forward our complaints to them, not to insult them, because they cannot respond for themselves. Then secondly, I just want to say, Honorable Chairperson, that while we have made our inputs as members of this committee, sitting here, I don't know, maybe I didn't hear Slung's Pumela. There is no court interdict in front of us. The application that we are dealing with, the application for adjournment, is an application by the PP's legal team. That is what we are dealing with. So those are my concerns and cautions to us as members of parliament. Thank you, Chair.
Chair, there's no one who's insulting.
Honorable Thagode.
There's no-
Honorable Chabalala.
Chair, it's Honorable Malema here.
Thank you, Honorable Chairperson.
Yes,
for
I've noted
acknowledging me.
Honorable
Giving our
Chabalala.
input.
Thank you for acknowledging me, Chairperson. Really, truly appreciate it. Chair, I just wanted to make a quick follow-up to what the Honorable Malema would have said. The part on the fact that he's making an application, if not an application, but he's submitting to the committee to say that they would seek for us to adjourn so that they get a legal opinion as EFF participation in this process. So I was not too sure, Chairperson, if we're allowed to ask the honorable member, what does that mean? Because now he's submitting to the committee. But beside what does that mean, the question that I wanted to ask is the fact that he says that we are engaging in an illegal process, hence they want us to adjourn. So I want to understand what is illegal about the process of this committee of parliament appointed by parliament. Really, that language for me, I'm just shocked. But I want clarification, Chairperson, because from where I'm seated, there's nothing illegal for us to be able to sit here and deliberate on what has been brought before the committee. Thank you, Chair.
Okay, thank you, Honorable Chabalala.
Chairperson.
Honorable Swela, you have a hand up.
Chairperson, I think I'm covered by Honorable Thagode, but I just want to check with us amongst other responsibilities of the committee that are we allowed to allow members to pull out, or because all of us who have been appointed by the speaker. I wanted just that clarity so that we are on same page, all of us. The request by Honorable Malema, I heard it, but my question is, do we have that authority to can allow any member to pull out as the committee? Thank you, Chair.
No, thank you, Honorable Siwela. That will be clarified. So I thought that you can now allow me to
Chair,
do what I've wanted to do.
Which must be clarified.
Who is speaking on the platform?
It's
the
me.
president. He says there were questions that were asked directly to him to
Malema,
clarify.
you want a third bite?
No, not a third bite. The Honorable Thagode made a terrible observation that when we disagree with the legal opinion, we're insulting those members. We're not insulting them. We disagree with them. And we must never be blackmailed into agreeing with things we don't agree with. And secondly, I've never said we're engaged in an illegal process. I said there are serious issues presented before us that include a possible contempt of court which can lead to arrest. So we want to consult so that we don't find ourselves on the wrong side of the law. That's why there is legal experts and legal arguments being made. We are laymen, as it were, and we are asking that we get a legal opinion on that matter. But for Honorable Thagode to confuse me with voting kettles, that I should mimic what they say, I'm not the type. You're confusing me with those types that you tell them what to say, not me. I've never insulted anyone. I don't agree with your legal officers, and I'm not insulting them. Their opinion is not correct. and they are biased. What is the insult about saying a person is biased? They are wrong.
Okay, thank you, Honorable Malema. As I indicated, members, I just want to make my own comments as a chair, both on the written and oral presentation today, and also would endeavor to reflect in summarizing your contributions as members into a decision of this committee. But perhaps before I do that, I need to start clarifying a few things. And this has been the case since we've started in the way we work. This committee has a support team. So every day when I open a meeting, I recognize the entire support team of this committee that would have started with us from day one. It is not by accident that I do that. And that support team is a support team of various teams of parliament, whether it's content, it's media, it's the kind of catering that we sometimes never recognize, or security, or the legal services. From day one, they are part of the functioning of the committee. They can never be linked to evidence leaders or even the legal team of the public protector. They are a team of this committee. So when we excuse the legal team of the public protector and the evidence leaders, they are not in the same space with them. They are us. And I thought that that's what we've always understood. And therefore, every day when I welcome and thank people, I make that recognition that this is who we are. So there's also, it's not a mistake that the lineup would have been designed in the way it was. It was important that we gave the public protector this 1 hour and a half, and for us to hear if there are any concerns or issues from the evidence leaders, and allow members to make their own clarities, and thereafter excuse both the evidence leaders and the public protector and her team, so that we remain as in committee. And this committee has this support team. So there must not be any confusion that the legal services of Parliament can never present anything to us until the external people can hear that. It can't work like that. I didn't know that I have to go to that extent and explain that this is a team that we've designed to be with us, that is driving, that has guided us, giving advice. Sometimes we might not like the advice that they did. We worked with them. They've created this reference journey that many scholars and students will have to study and read. I do want all of us as members of Parliament of this Section 194 committee to recognize them as such. The second point, we've said this before, that this is the biggest committee that we've ever had since 1994. This is not a committee of 11 members like other portfolio committees. It's a committee of all the parties that are in Parliament, and to that extent, it has gone up to 36. At some point at the beginning, it was 35 members because the ATM elected not to participate at the beginning of this committee. And then later on, it is their decision to participate or not to participate. Nobody can force, not a speaker, not a chairperson of this committee can force anybody to do that. It is their right. They have been voted to be members of parliament. They've canvassed, they've gone throughout the country to seek for those votes. It is their right to represent that kind of voice. And that remains so. So all parties are here. They might not be here, all of them, every meeting we meet. You know that, you see that, and the records will speak for themselves in relation to that. So I think, Honorable Suela, I'm going to summarize the issues, because in the summary, I also have to recognize each and every speaker that would have spoken here and the parties and the issues they have raised. And that's what I thought you would allow me to do. And now, just to do my own prepared comments or remarks as I go to this summary, because much of what I will say in some way, colleagues, has been covered by yourselves. But nonetheless, I feel it's important to put my views on the matter on record. The recusal application was given close consideration by two members in question. Mr. Milam submitted reason why he would not recuse himself. I submitted detailed reasons why I would not recuse myself. In addition to our submissions, the committee obtained a comprehensive opinion from an eminent senior counsel who advised that no case for recusal had been made out against either Mr. Milam or myself. The committee considered the PP's application, the response from the evidence leaders, as we have witnessed, the opinion and the reason for Mr. Milam and I, and the committee, when it met, was satisfied that no case for recusal has been made out. This is a decision of the committee. The PP now seeks an adjournment of these proceedings while she challenges the recusal decision in court. I'm of the view, therefore, colleagues, that such adjournment should not be granted, and for the reasons I will set out. However, as indicated, I will approach this matter as a committee decision and do not seek to decide on behalf of members. I merely share my own rationale. The committee is discharging a constitutional obligation imposed by Section 194 of the Constitution, and under Section 237 of the Constitution, it says emphatically that it must do so diligently and without delay. That's a task on us. The Constitutional Court has already confirmed the importance of the committee holding the PP accountable in terms of Section 194 of the Constitution, with due regard to the fact that her term of office expires in October 2023. As the Constitutional Court noted in the Speaker versus Public Protector, the exercise of holding the PP accountable is not the sort of matter that should be dragged out. And there is a strong public interest in finalizing such an important matter. This is the Constitutional Court. On the case that was brought in front of it, that would have started in the Western Cape High Court, where the public protector had 12 prayers that she had. And she was successful in 2 of those prayers. One relating to the issue of her legal representation, as you would have seen, and the second one on the involvement of the judge in the panel. That matter we appealed and it went to the Constitutional Court. And the Constitutional Court found in our favor on the issue of the involvement of the judge and found in her favor on the issue of legal representation. That's why today she's here with the legal team actively participating. And that work would have been prepared for us, would have been properly advised by the legal services. And so facts on the ground, this is a from the Concord, that's how far would have taken this and would have had success. The second matter would have also recently, when we started these proceedings, Advocate Mpofu came here and indicated that again was going to the Western Cape High Court on a number of issues, including the suspension, but in relation to the Section 194 committee, that this process was illegal and unlawful, and there were a number of prayers. None of those by the Western Cape High Court, they succeeded in those prayers. And so that work again, we're guided on by our legal services. So it is useful to briefly share the timeline of this matter to date. The NA, having accepted the independent panel report, resolved on the 16th of March 2021 to proceed with this Section 194 inquiry. The committee was duly constituted and I was elected chairperson thereafter on the 20th of July 2021, 15 months ago. The hearings only began on 11 July 2022. Due to various legal challenges brought by the public protector, and now more than 3 months later, we have yet to conclude the leading of evidence by the evidence leaders, whereas our initial program anticipated that we should have already adopted our report by the 29th of September of this year. It is clear, therefore, that we are far from concluding this process. This is not helped by the fact that members do not have the luxury of being solely dedicated to the work of this committee. Indeed, members are required to participate in other many committees whose oversight work and legislative process are also important. There can be no doubt that much time has already been dedicated and the process has already been long and drawn out. If the committee were to adjourn its proceedings to allow the challenge to the recusal decisions to be ventilated in courts, it may never resume its proceedings, as any finding by the High Court may be appealed through various other courts, as we have seen already, and those appeals could take years to conclude. This may well be so even in the face of the stage of that. By that stage, the PP's term of office would have been terminated by operation of law, and the duty of this House to ensure accountability will have been lost. We would in fact have failed as Parliament in performance of our obligations. We would have failed. The PP was given a full and reasonable opportunity to make a recusal application. However, that application was in many instances not supported by the necessary level of detail and supporting documentation. Despite that, I made great efforts to respond to the generalized allegations and that were made against me in as detailed a manner as possible. That lack of specificity has not been corrected in the application before us today. It continues. In other words, I do not see any new supporting information in this application. The recusal application has already received extensive consideration by the subjects of the complaint, by senior counsel, and by the committee. It has been determined to have no merit. We have made that conclusion. That has not been changed by this application that we have listened to today, which merely repeats some of the recusal grounds and criticizes the independent legal opinion, but does not set out any additional evidence in support of the claims made. There would, accordingly, in my mind, be no justification in pausing these hugely important proceedings in order to allow a court to consider what this committee has concluded is a meritless application. The application does not indicate that the PP will have any prospects of success and would have asked that in the proposed legal proceedings. The fact that there are 12 grounds is meaningless if they are without merit. Nevertheless, if a court should disagree with the committee and the independent senior counsel and should further conclude that it would not contravene the separation of powers principle to interfere in the committee's proceedings, then it may issue an interdict or any other relief. The committee will respond to any such order lawfully and responsibly. In paragraph 51 of the application, the remark is made that the dismissing of the application can only come from spite. That would have been even flighted here today. This accusation is unfortunate and baseless. The PP is entitled to have a properly made application is duly considered. That entitlement has been observed. However, she is not entitled to have any application she wishes granted automatically, particularly when she has not made out an adequate justification. For these reasons, colleagues, I'm of the view that the adjournment application must be dismissed. However, in the light of the continued allegations of bias made against me and the legal advisor's advice that a risk assessment be made, I'm led by the decision of this committee on the matter. And having heard you making your own contributions today, now, it's important, therefore, to summarize our meetings and proceedings in the following manner, that we must note the contributions and suggestions that says maybe there is a need to consider involving a negotiated approach and settlement, as would have been sponsored by Honorable Heron. However, other members are in support of that, but not as a standalone. To say that, firstly, many members would have spoken here to say, let's reject this application, decline it, proceed with our work, and that which has been suggested by Honorable Heron can still be done as well as we proceed with the work. So you don't have binaries here, either or that all of that can happen. If I'm correctly summarizing what I think I would have been listening to here. And further, members here have been very strong to say they would still want to consider their options, because some would not be happy, and they would make argument about not happy about legal advice, but therefore want to proceed and do their own legal advice to satisfy themselves. I don't think we can stop that goal. We can never say that nobody must do that. That must be allowed. So people must exercise those kind of options. But that should not stop us from proceeding with our work, especially when it is very clear. Honorable Maneni has been very clear about the Concord has restarted this process, and therefore, and as indicated, and as I would have reflected here, in front of us, there is no interdict. There is no legal impediment that we have on this issue, not on any other issue. And therefore, there is no reason for this committee to decide otherwise not to proceed. We therefore have to proceed, and when there is such legal impediment or interdict, we'll have to observe that as lawful citizen and as a lawful institution in that regard. And therefore, colleagues, it is my view that therefore, having listened to you, the summary of our meeting in the main says the application brought in front of this committee today by the public protector for postponement is rejected. And that we want to proceed with our work. There are suggestions about improving on how the teams can work in an integrated way. The evidence leaders, the public protector team, to speed up the process of the way forward, including ensuring that the public protector is afforded her opportunity to present her case and reasons why she must be exonerated. We're looking forward to that, and that must be done. As I would have indicated in the morning, if then that is our decision, having noted those minority interventions about exercising further options to seek further legal opinion as we proceed with our work, but also incorporating the improvement in the manner in which the committee must work under the guidance of the chairperson for all of these teams. I would have indicated in the morning that therefore, if that becomes our decision, we therefore need to proceed with speed. and allow Advocate Mpofu, the PP team, to cross-examine Ms. Nelisiwe Thejane and the evidence leaders to start leading the evidence of Ms. Niels van der Merwe. We're then going to have to convene that back room to properly plan that 7-day period or whatever period that would be agreed to, about when, therefore, once we concluded with these two witnesses, as of tomorrow, we are then going to need to ensure that the team worked very smoothly in ensuring that post the Niels van der Merwe leading of evidence, there is a clear program of how we're getting into the witnesses that would have been identified by the public protector and the public protector herself. So in the platform, we would have invited the last witness that must be cross-examined. She would have been in the platform, and I would have indicated in the correspondence and even this morning that it is the intention that, depending on the outcome of the meeting today, if this committee declines the application, it means we proceed with our work immediately. And therefore, it has been planned that Friday has been set aside, in fact today, but it's clear that today is likely no longer going to be relevant, that we need to proceed as from tomorrow with the remaining 1.5 witness to conclude. That's the summary I want to give colleagues before we ask the evidence leaders and the team of the public to come in order for them to be notified of this decision. Anybody with a difficulty with that will indicate so. Honorable Mailam.
Chair, it's not a difficulty per se, but could we get an indication of at least the next week's sittings of this committee?
It will be possible to do that, but maybe let me repeat what I said. What we have remaining is the cross-examination of Ms. Nelisiwe Thejane, and that cross-examination is going to be done by the PP legal team. That should be a period of 2 hours, 2.5 hours, okay, as planned. And then the next process is the leading of evidence of Mr. Niels van der Merwe, with cross-examination following, with members asking, and then we conclude that phase of witnesses. Hence, we would have set today and tomorrow for that. Now, if today we're not able to start with any of those two witnesses, tomorrow, the first thing, that's where we're starting. It's not possible that today, because we would not have wanted to anticipate. So at least Mr. Ngoma can come tomorrow at the end of the meeting, and then as we proceed and say this is the program going forward. That program might then indicate that we'll give the public 7 days to prepare. Because that's in our directives. But that I think he can be able to indicate tomorrow. It will be unfair that I put him on the spot now. I hope that answers your question. Thank you. Honorable Maneli.
No, thanks, Chair. I wanted to check if the Chair would be persuaded on this point that indeed would not preempt what the actual outcome of this meeting would have been, because objectively we had to look at what has been submitted, and objectively we have arrived at a decision. I'm just worried about the gap that gets created in between, and therefore would have suggested that if everything else that you made in the summary was to be accommodated, probably maybe 2 weeks was too much of a stretch. The 7 days is something you may want to look at, that we allow that backroom work to happen. If witnesses could be persuaded, the remaining ones, so that when you start with those witnesses, we don't get many breaks in between. because we may then get to another application instead of dealing with the witnesses that must come before the committee. But also, Chair, anybody would have wanted to exercise any other option. And by the way, you've also been given yourself an option that in case you want to even go the independent, I'm sure there'll be no question in the next meeting where you got a legal opinion, because even the other meeting, there was that mandate that you can look at the legal opinion outside. So I'm just saying you can accommodate all that so that when you restart the process, we can really proceed to get to a point of completion. But of course, if arrangements are different, Chair, I submit to a ruling. I just thought, because I raised the point about the 2 weeks, maybe the 2 weeks was too much of a stretch, but in principle, I was just raising a point that says we should not be seen to be pursuing the PP, but pursue justice. I submit, Chair.
Yeah, thank you for that. They would have been informed as well about the planned session of today and tomorrow. That would have been discussed with them. I am aware that the leading of evidence might need more than a day, given the amount of work that is there. So that's something else. But today and tomorrow has been set. We've been given that by Parliament to work on that. So as things stand, on are the extra days, 1 or 2 days, to complete this 1.5 witness. It's important to do that and then create a gap between that and the 7 days to allow the public protector to be ready for the next session. So we should be ready therefore for tomorrow. Any other questions, concerns raised? Yes, Honorable Gondo.
Through you, Chair, once we are done with this 1.5, witnesses we have left, please, Chair, let's be mindful of the time in terms of, any breaks that we take in between. You will know we took a break between the recusal applications, and that set us back quite a bit. And, you've also pointed out in your submissions that, time is against us. We are a committee with a lifespan, and we have to always be mindful of that fact, that we are not one of those committees that, are standing, we have a lifespan. Thank you very much, Chair.
Yeah. I want to take it back to you, honorable members, that it's now just after 4. Okay, so today seems to have been exhausted by this, even before we relay the decision and call the members. But to conclude this, it might be important that you also yourself become flexible. That if we can't finish tomorrow, even if it's virtual, we'll finish as we have done before. We did this even on a Saturday, so that we're able to clear this first phase. It's important that we do that. And then Ngoma then should be able to indicate tomorrow the next steps in terms of the program. Because the issue here is Honorable Maneli is not even pursuing anybody. It is pursuing our work that we need to conclude. There's been too many stop-starts. And you're losing the momentum. It's even worse for issues of cross-examination, where a witness would have been here a month ago. It's undesirable that we work in that way. So I'm open to you, members. If you don't have any suggestions, we will indicate to you even after the meeting. You're fine. Okay, we'll adjourn therefore for 10 minutes so that we're able to call them back and convey the decision. Please get your attention. The time now is 22 minutes past 4. Our sessions are normally from 10 to 5. Let me first start with an apology to both the public protector and the legal team, as well as the evidence leaders, that our discussion would have extended beyond the time limit we would have hoped for. And therefore, we seriously want to apologize with all the precious work you have to do and go through, that we have to keep you redundant, if I may put it that way. So I want to start with that apology from the committee. It was important that we exhaust our discussions, because we are such a vibrant and robust committee that's made up of people from different backgrounds, let alone the fact that it's an all-party committee, unlike others that have 6 and 5 as representation. So the reason we, as indicated in the morning, that after such a discussion, we would then, having asked you to excuse ourselves, we would then call you in and relay our own decision to you in that regard. So I think I'm ready to do that now.
Yeah, before you do that, Chair.
Hello.
Yes, Chair. Yes, Mr. Malema.
Is that a point of order?
No, I just wanted you in that decision you are about to announce to note the objection of the EFF.
Okay, thank you, Honorable Malema, for the objection before I announce the decision.
No,
thank you.
Didn't a summary earlier and then I couldn't come in, so.
Okay. Thank you, Honorable Malema. Maybe you should have allowed the chair, because the chair would have reflected that important view that you are raising now. Thank you for that, but let me proceed, colleagues, and say we, after a lengthy deliberations, was very constructive, and as I indicated, not easy discussions that we've had, because we have to consider all facets of these matters, especially having listened to the both the written and oral presentation. Now, before I proceed, now there's another hand. Advocate Mpofu, you don't want to hear the decision.
No, I know the decision, Chair. I told you in the morning. No, I'm saying, Chair, that in the interest of time, we actually, even though you excluded us from here unfairly, the thing was on YouTube and on 408, so you should have just allowed us to sit here. So we've been listening to everything. So I'm just sparing you all how difficult the decision was. We saw how difficult it was, very difficult. So we know, we were watching. That's why we came here. When Tim Ngosi was coming to fetch us, we were already at the door. Thank you.
You're out of order, Advocate Mpofu.
No, I'm trying to save you time.
I take that
Take your time.
On a lighter note. Thank you, Advocate Mpofu. Well, then the YouTube would have helped us, but what I will do, I will give you a very brief summary. Let me start saying that. And that we are going to, humanly possible also by tonight, to give you something in writing, in detail, formally, of the decision itself. But the decision of the committee, the committee has resolved that having listened to your presentation written and orally, and the discussion that we got into as members, that the committee is of the view that the application for adjournment or postponement is declined by this committee, and that we want to endeavor, secondly, that having declined that, we want to proceed with our work of this committee, as I would have indicated in the morning in my opening remarks, and that we need to ensure that we make that backroom work as we go towards the issues of the way forward, both for what we do in the next day and the break of that 7 days, but also to, as you would have seen in the YouTube and listened to my summary, I would have noted, and let me also note that that decision would have had a version of a minority view that indicated that some parties would want, especially the EFF, to exercise an option of further seeking a legal opinion on the basis of not having much confidence on the parliamentary legal opinion. That is what Honorable Malema is recording as an objection as part of the summary decision that I'm indicating. So that's our decision to both evidence leaders and the public protector team. As I have indicated, we will furnish you with the detailed reasons formally in writing in that regard. Thank you. Before I adjourn, any remarks, comments before I close the meeting? None.
No,
We mamele ku YouTube,
noted.
Thank you. Thank you, Advocate Mpofu. Advocate Bauer?
Chair, can we just sort out housekeeping tomorrow? We're going to start with the cross-examination of Mr. Thejane and then go on to Mr. van der Merwe.
Okay. Cross-examination, I have to look this side because that's everybody else would have been done by with Mr. Thejane. Advocate Mpofu.
Thank you, Honorable Chair. Yeah. Yes. No, thank you. We, as I said, we have listened to some of the input. We have problems with the fact that some of the things that was said in our absence could have been said when we were here for the members who were making remarks about our own input when they had a chance to say it, and also the parliamentary advisors were passing remarks about the input, which is also part of the unfairness. But be that as it may, Chair, there are also some factual issues which you don't want to get into that we heard being said about our own input, including the fact that we once went to court and asked for 12 prayers, which never happened, but that's fine. And also that those previous cases were done on the advice of the parliamentary advisors. We saw 2 senior counsels in court, but that's fine. There was just some factual inaccuracies, which if we were here, we would have corrected. Chairperson, as I indicated earlier, the decision really does not come as a surprise. So what we're going to do now, Chair, is just to explain, to revisit what we said to you in the morning, which was that the mandate, our mandate as the legal team was only to come here and do the application for the adjournment. And we made that clear in the letter we wrote to you on the 21st of October, and in the application we submitted on Monday and this morning as well. So that's it. What that means is that we are not able to take part in any of the further illegal activities, which would involve anything beyond the application, as we indicated this morning, of the adjournment, because to do so would be to acquiesce in participation in this committee as it is currently constituted. It's completely illegal. Your question was about cross-examination, and I think the answer therefore is that anything beyond the point of the application, even breathing after that point, would be an endorsement of the illegal activities of this committee. And as I say, in any event, beyond the mandate that we were asked to perform today. So I'm afraid then, as far as the legal team is concerned, at least that will be as far as we can take it. And good luck. We'll see you again, maybe, or maybe not.
Let me do this then through, so that I get much clarity. So are you indicating that you are electing not to do cross-examination tomorrow, nor being part of the process of the evidence leaders leading evidence of the next witness? I need that to be clear. And is that what the public protector say?
No, the public protector will speak for herself. In fact, once I finish speaking here now, she can only speak for herself. As I said, my mandate, once my mandate comes to an end, I cannot speak for her. So if you don't mind, Chair, can you excuse us, the legal team, and then maybe you can ask those questions from the public protector.
Okay, you want to ask something?
Chair, sorry, Advocate Mpofu, sorry, my apologies. I don't.
No, it's fine. You can talk to me
unduly-
as a colleague.
Unduly detain you. You are in instruction and brief from CNEGO attorneys. Can I just understand, are you withdrawing as counsel, or is CNEGO attorneys withdrawing as attorneys? Or can I just, or do you prefer that I ask that question of the public protector?
Yeah, you can ask whatever you want to ask. I'm done.
Chair, Advocate Mpofu has withdrawn. Release him.
Thank you.
Gena Chairperson, when's the running?
Thank you. Thank you.
Yeah,
Thank you, colleagues. I'm now going to invite the public protector. Tomorrow we're planned to continue with the cross-examination of Mr. Thejane. Your legal team has just indicated that you would have given them a mandate that they must leave. And tomorrow we're planning to proceed.
No, on a point of order, Chair. On a point of order. On a point of order, Chair. Point of order, Chair.
Public protector. What is the point of order?
The point of order is that you are distorting what the legal team of the public protector said. They never said she instructed them to withdraw. They never said that. They said, as far as they are concerned, that's where their mandate ends. So why do you say to her, she hasn't given an illegal team instruction to withdraw? They never said that.
Thank you, Honorable Malema. If that's your point of order, that point of order is not sustained because the senior counsel would have been working with the attorneys of the public protector. So the issue of the mandate has a source. And I'm now trying to verify issues with the public protector who accounts to this committee. Because I'm trying to indicate to her the work that we want to proceed to do. But maybe before I proceed, Advocate Bauer, you want to come in?
Yes, Chair. My apologies for interrupting, but before we proceed with the work and maybe if the public protector doesn't mind me asking the question directly, as in ordinary parlance, legal counsel get their mandate from an attorney. An attorney is the only person who could terminate the mandate on an instruction from a client. In this case, the client is the public protector. And so I just want clarity as to whether the public protector had given Sienego an instruction to terminate her counsel's mandate. Thank you.
No, thank you, Advocate Bauer. I was in my own way going there, but I think you've...
Sorry, Chair, there's a second question to that because the attorney from Sienego also walked out. So the second question to that is whether the public protector then also terminated the mandate of Sienego.
Thank you, Advocate Bauer. Public protector?
Yeah, that's law 101, Chair. It does not need shouting, just need reasoning. Thank you.
Nah, there's no shouting when a man. You are suffering
Just pause.
shouting.
Honorable Mola. Honorable Mola.
Mola, you are out of order. You are out of order.
The mind of a peanut. A mind the size of a rat poo-poo. That's what you are suffering from.
You are suffering from a mind of a cockroach. Yourself.
The cockroach has got no mind. That's why you don't know that
you are a cockroach.
Mind. You and the cockroach are the same. You are a small boy who has nothing to show in the history of politics except opportunism. You are here because you are hungry. You have nothing to offer. Poverty brought you here.
Honorable Malema, are you done?
Why are you not asking your colleague if he's done? I'm not your member. I'm not your member. Don't think I'm a member of the ANC. Why are you not asking your member if he's done? Because he's the one who spoke nonsense here. Why are you not asking him? Don't confuse me for your members who are normal. Don't do that.
Honorable Malema.
Yes, sir.
Am I addressing you? Do not mute, Honorable Malema. I'm addressing you.
Yeah, I'm listening.
You are using unparliamentary language in this inquiry session. I would want you to withdraw that.
Withdraw what?
Okay.
Withdraw what? Which one is unparliamentary?
You can't refer, both of you, and I'm going to address both of you. You can't refer to a member in the language that you have just used.
Okay, why not starting with the one who started? Why not starting with him? You are starting with me because I'm not a member of the ANC. That members of the ANC
I don't even know who started, but I'm speaking to you now, and I'll address both of you.
Start with him. Why not start? It's him who started. Start with him.
Honorable Malema, I don't think that that's how we work in Parliament, that you must indicate to a presiding officer where the presiding officer and what he or she must do.
No,
I'm
but
asking you,
you are being unfair.
who
started with cockroaches.
Parliamentary.
Chair, you're out of order yourself. It's Ngola who started with cockroaches. It's him.
I have not recognized you, Honorable Mautwe. I will come back.
To say, please, you are unfair. I'm asking you, please, let's continue.
I've had you doing exchanges with Honorable Malema, using an unparliamentary language of cockroaches. You're on the platform now.
Chair, I rose and said, that is law 101. It does not need any shouting. I did not refer to anyone in the committee, nor even outside this committee. I just passed a remark. It is when Honorable Malema shouted at me and said a lot of things when I retaliated. But Chair, for the sake of progress, I withdraw unconditionally. Thank you very much.
What are you withdrawing the words? Which words did you use?
The coach's words, Chair, I withdraw unconditionally. Thank you.
Thank you for withdrawing that. Honorable Malema.
Yes.
I have heard you using also unparliamentary language in your exchange with Honorable Ngola. I would like you to withdraw that.
Which one? You may not like what I said, but which one is unparliamentary? Which one?
Poverty.
Huh?
Rats, poverty, cockroaches, that.
No, I said he was brought by poverty into this thing. He has got no conviction of his own. How is that unparliamentary?
Honorable Malema, I'm asking that you withdraw in the same way I've done with Honorable Ngola.
Okay, I withdraw. I want to hear public protector. I'm withdrawing.
Thank you, thank you, Honorable Malema. You can remove your hand, Honorable Ngola. Thank you.
And please,
Apologies for that, public protector.
Chair, please tell Mola not to just speak without being recognized. Please.
I now have the public protector on the platform.
Thank you.
Because I've recognized her. The public protector.
Thank you, Chairperson. Thank you, honorable members. I think for correction, Chair, I didn't say, or I didn't give a mandate to my legal team to, yes. So I think that's what they've discussed with the attorneys. And for now, I'm not in a position to, I'll have to discuss with them because we didn't discuss the continuation of the process because the issue was for them to apply for this process. So I will have to go back and discuss with them, or alternatively, if they decide to withdraw, especially the attorney of record, then I'll have to find a way of finding an attorney who will have to proceed with the matter, or as well alternatively convince the current legal team.
That's I hope the response helps Advocate Bauer that there's no mandate to terminate the attorneys.
No, well, Mr. Advocate Mpofu's words was his mandate has been terminated. In other words, he doesn't have a mandate beyond these proceedings. Advocate Mpofu and his legal team was engaged to represent Advocate Mkubani through the Section 194 process, as was Sianego attorneys, but Sianego attorneys also walked out. There is authority in the courts, which I don't want to get embroiled in giving the committee legal advice, but I would suggest that your legal advisor go and look at what the position is in respect of when legal representatives walk out of proceedings and what the consequences are for hearings. I've not giving the committee legal advice. That's not my role as an evidence leader. And I think
Chair.
Okay. I see now a couple of hands. I'll start with Honorable Malema, Maneli, Mananiso, and Chabalala and Skosana.
Yes, Chairperson, I think that there are two issues I want to raise. One is that the public protector gave the response she gave, and she's entitled to a legal representatives. And this put these proceedings to an end, and then you can decide when and how we're going to meet so that she can do her consultations and maybe find a new legal representatives or anything of that sort, or convince the same people to come, because she hasn't been privy to that type of an action that we have observed. But the second thing, Chair, is that because you have decided to proceed with this committee, depending on your ruling, we are considering withdrawing as well as the EFF, because we don't think that we should take these matters light. The advocate said we're engaged in an illegal process and therefore they are unable to proceed with engagement in the illegal process. And I said earlier, we're asking for adjournment to go and consult our legal team so that we see how we proceed with these matters. That matter is not being even considered by so-called colleagues, that when the other colleague says, can we be given an opportunity to look into these matters so that we are confidently moving at the same level and speed? No, we're being brushed off like that. So I think that she's entitled to a legal representative and we must allow her. And if you insist on proceeding, we're also going to withdraw from this proceeding. Thanks.
Thank you, Honorable Malema. Honorable Olomisa.
Thank you, Chairperson. Honorable Malema has like to say, but for now, what I would suggest,
we're losing
a
you.
meeting between
you cut. We did not
Hello?
hear. Please repeat.
I would suggest that you postpone this sitting today, subject to the evidence leader and the office of the public protector, the public protector rather, ironing out this and what would be the way forward as from tomorrow. At least by tomorrow when we meet, you should be in a position to tell us and the country as to where the process is. Thank you.
Thank you, Honorable Olomisa. Honorable Nkosi.
No, Chair, I think that what has happened is unfortunate. I, however, think that yourselves as chair, in terms of the directives, now have the opportunity to give direction as to what should happen. Firstly, we should recognize that the public protector has, as per decision of the CC, the right to have legal representation. We can't depart from that, and we must respect that at all times. And two, in that regard, that she be afforded an opportunity to indicate to yourself what her next steps should be, and that would require that you engage with her. And that engagement should, in my opinion, be given space to take effect. Thirdly, that without taking advice from the legal, the evidence leaders, but that we ask what the implications of the withdrawal are from our legal team. Thank you.
Thank you, Honorable Nkosi. Honorable Suela.
Thank you, Chairperson. I think Honorable Nkosi has covered me because, Chair, we need to seek advice from our legal team because this has just happened and we have got our program which we are saying we are proceeding. And I believe you will have to engage with advocate, the PP, since she's saying she didn't mandate them to withdraw. She's still going to consult. But for me, I believe that should happen urgently, so that we proceed with the program. Thank you.
Thank you. Honorable Klape, followed by Ngola.
Thank you, Chair. Chair, I would also submit that this was unexpected and unfortunate. We stop here so that we don't speculate. You retreat to the back room with the legal team, evidence leader, and the public protector. And tomorrow we should be able to give us a way forward so that we don't cloud this with many ideas of what if or what could happen. Thanks.
Thank you very much. I think Honorable Ngola.
Thank you, Chair. I think I agree with a lot of submissions, except to equally submit that why can't we maybe allow them that they should not come to the committee tomorrow so that they sort their own things out. Was I'm worried, Chair, they were supposed to have started with a cross-examination, and by the look of things and by the material conditions, it does not seem like there will be. I'm not sure, Chair, if it won't derail us more if we give them even tomorrow to sort their issues out. Thank you.
It's fine. I think I have a sense of the summary. Honorable Maneli, because you have raised your hand, if you want to withdraw, it's fine. Honorable Maneli and then Skosana. Or maybe before that, Advocate Bauer.
We have remained silent when the issue came up before the committee about the evidence leaders meeting in the back room with the representatives of the public protector when the committee was talking about it earlier on. We don't have a mandate from the committee of any sorts to enter into any sort of arrangements with the public protector, which would be an antithesis or in contravention of a decision that the committee has already taken. So for me to go into a back room with the legal team of the public protector, I wouldn't know where my authority comes from to make any deal with them, which is different to a decision taken from this committee. I don't mean any disrespect to the suggestion made, but I do think I must clarify that from our position, we wouldn't know what we're entitled to agree to and what we wouldn't be entitled to agree to. And we could, and we wouldn't want to do that with the public protector on our own. And it doesn't seem to be clear whether the instructing attorney has withdrawn from the matter. I'm not sure about what the rules are about counsel out of their own withdrawing from a mandate, but it wasn't quite clear how this occurs. But be that as it may, I have great reservations about it being left to us as evidence leaders to make arrangements with the public protector's legal team.
That's fine. I thought the suggestion, but let me hear you because we will have to go back to the legal services team. Maneli?
No, thank you, Chair. I think the first point is really to once again emphasize that on the basis of the submission, there's already a decision. And that decision is to proceed. And I think the point was to really look at how you operationalize that decision. And at this point, we are faced with the practicality that there is something that has happened. I think Honorable Ngola says it, that the material conditions are now dictating to us what needs to be done. And we can't keep that shape that we had because there's this reality. And the understanding, Chair, was that the backroom discussion, it's about the operationalization of that decision. And it may be also an opportune moment, Chair, to consider all the points that have been raised, including what you would have recognized as minority submission, if that's what you would want to call it. that an opportunity to have that discussion and creating space that all these other matters could take place, including in a situation where, as the court would have discussed and agreed, if you need further opinion on the matter, you still have space to do that in such a period. So that when you convene, I think that's the sense South Africans may want to get, is that once we reconvene, and whether you get to cross-examination and all that, firstly, an opportunity would have been given to the public protector to indicate or elect on how should participate, because again, even the legal provision, it's really a point for her to exercise. And that will be what she would elect to look at, whether that's the route to go or not. But even at this point, Chair, if we're to take what has been presented to us, there's still gonna be clarity in another backroom, which is the PP's backroom, whether there is a withdrawal or not, and whether there was a misunderstanding probably of what she would have instructed or not instructed. So I just thought that it's important that we do not get to a point where we think there's no decision. That decision has been there. It's the operationalization. Now there are new developments, and in that score, I don't think even the evidence leaders will be launched in this case, because the chair person, as per the committee discussion, coordinates that engagement and who has got full understanding of where the committee comes from in terms of such a discussion, which makes it indeed what Honorable Ngola puts up to be important, Chair, that looking at the time now, it may be important to look at using tomorrow to still get this ironed out than to meet just to get a sense that there are still discussions. Otherwise, we are going to meet, stop, and it may cast some doubt on whether we would want to proceed or not when we have decided that we are proceeding. Thank you.
No, thank you. Maybe I think I won't go to other members at this stage, is to take the advice of Honorable Jape, that will retreat. I'll remain here as a chair and the team with the public protector. Members can leave knowing that tomorrow's meeting is still standing unless there's further notice. We're not going to get into that discussion now. So you have to leave here knowing that tomorrow's meeting as scheduled still stands until advised otherwise. Okay, so that we clarify, we retreat as suggested properly and clarify the matters. Is that in order, Namadzinga and Skosana, because you had your last two hands up, but that's what I want to roll on. Honorable Skosan.
Yeah, no, thanks, Chair. No, I hear your ruling. However, just to make one point, I think we must also make sure that we are not being unfair to the witnesses who are supposed to appear before the committee. You've got Mr. Thejane and Mr. Niels van der Merwe, who are always on half cash. They always come, we don't deal with them, we deal with other matters. Another date is being set, they always come, you see. So if you say the meeting tomorrow continues, if it happens that the meeting doesn't continue, they have to make arrangement to be in the meeting, then the meeting doesn't continue, or the meeting does continue, but we don't deal with their evidence. So I think it also becomes unfair on their part, because there's always uncertainty as to whether are they going to give evidence or not, are they going to be cross-questioned or not. So, my view, I was aligning myself with Honorable Maneli.
Just let me stop you there, because I don't want us to get into that discussion.
All right.
I thought I must give you because you've raised your hand.
All right.
So that you allow us to deal with all of those issues you're raising, instead of having them ventilated here in this forum. Honorable Chabalala.
No, Chair, in exactly what you just mentioned now, as much as a member had many questions that I also wanted to pose to the PP on the proceedings. However, I'm going to respect the fact that, you know, you look into the rules, 164, it speaks about interruption, suspension, or adjournment. So that we're on record in a way how the chair then adjourns the meeting. Then it's on record. B speaks about you may change the date for the resumption of business, provided reasonable notice is given. And I think that's what Honorable Skosana is trying to raise. I just thought that let's, at least when you close it, there is something that gives us on record, even though I was kind of worried with what Advocate Bauer said when she said they don't have mandate to do the back room outside. So those are the things, but let's leave it at that, Chairperson, and trust you that you will consider all these matters. But when you need the committee as a matter of urgency, so that we are able to deliver these matters and ask questions, please let's do so. Thanks, Chair.
Thank you. Honorable Sokazi, the last one.
Yes, Chair. My question really touches on what the evidence leaders indicated. We are not clear on what the current conditions are. And I am not sure now if that is being determined offline between yourself, the evidence leader, and the public protector, because it is this committee that needs to make a decision. So the conditions needs to be clear to us as well, whether the public protector is without legal representation, and on the basis of what that legal representation has now left. Because this is an oversight body. The public protector is accountable to this parliament, and we cannot get this process to be delayed. The conditions are still the same. I think the honorable member has now indicated that the conditions are exactly the same. This committee has decided to proceed, and the committee has deliberated on that. So the basis of this current interruption, then the conditions, on what basis is, we need to know what that is. Does the public protector, and it needs to be timelined. We cannot come tomorrow. There is not only the rights of the public protector, there is the rights of witnesses. There is the obligation of this committee that needs to be considered. And we cannot be in a position where we have a delay that is on the basis of a technicality. So we need to know what Advocate Bauer has indicated. What are the conditions currently in terms of legal representation for the public protector? Because that will indicate to us how we proceed, and it must be timelined.
Effectively, what are you suggesting, Honorable Sukas?
Richard, I didn't hear.
Effectively, what are you suggesting?
What I'm asking is if the public protector can answer us and tell us now, what are the conditions that her team has left? What have been communicated to her so that we know whether she is proceeding with a current legal representation, representatives, or is she without representatives? Because certainly there must have been communication between the public protector and a legal representative, both of which were here.
On a point of order, Chair.
Responded to that.
No, it is not clear to me. What has been communicated was, yes.
All right, let me know.
On a point of order, Chair.
Public protector?
No, on a point of order, Chair.
Public protector?
Point of order, Chair. Point of order.
Point of order.
Chair,
point of
you
order.
asked the public protector what is the situation. She answered you. What more do you want from her? She answered you. This is the same question you asked.
Chairperson, I'm not speaking to Mr. Malema.
Who said you are speaking to me? Who said you are speaking to me? Am I interested in speaking to you? I wouldn't be interested to speak to a person like you. I'm speaking to a chair. I'm not speaking to you. I don't speak to a type. I'm not speaking to you. Chair, I'm not speaking to her. I'm speaking to you. So you asked the public protector that question. She answered. She's going to find out. She's going to speak to the legal representatives. and should be able to advise once she has had a conversation with the legal team. What more do you want from her? She's entitled to have a legal representative. Wanting to speak to her without a legal representative is an attempt to put a cross-examine her without a legal representative. It's wrong. It's illegal.
Okay. And Honorable Malema, Honorable Lagut.
Thank you very much, Honorable Chairperson. I think you gave us some marching orders by saying that you'll release this committee and you'll sit behind so that you discuss whatever you will be discussing as the chairperson of this committee, if I heard you correctly. So I would suggest that you do that, chairperson. Then communication will come to us as members of parliament as to what is the way forward from now onwards. We cannot keep on going around on circles. Thanks, Chair.
Okay. That's what I would have suggested, members. So that you, okay, public protector?
No, I wanted to clarify, Chairperson, that what I said is I cannot proceed without my legal team, and not to say we discussed this because I think everybody heard there's a recording that they will just end it for today here because they said they cannot proceed with this illegal process. So I would ask that, I don't know, but you said you would want possibly for us to discuss. So I don't know, how do I discuss without my legal representation, which is a constitutional right, which the court said I should be having. So hence I am saying I'll have to discuss with them whether, and even including the attorney. Indeed, we know that the attorney briefs the counsel, and I have to decide the legal team of my choice. So, and they didn't even say they are terminating. I must find out from them, are they willing to proceed with me, or then, Chairperson, I'll have to start afresh and get a new legal team. And if I get a new legal team, that's another challenge because then it might delay the whole process because the new legal team must start afresh and go through all the evidence. So I would want to be given an opportunity to engage with them because I don't know why this came out the way it did. But anyway, it's in your hands, Chairperson.
Chair, I'm sorry, I apologize for my ignorance. Do I understand the public protector to say that you were completely taken aback by them leaving today?
Again, on a point of order, Chair. On a point of order.
I will have to answer you as the evidence leader. What I'm saying is, Ms. Sukras was saying, what did they say? I'm saying we didn't discuss such issues. We were discussing what we came here for, the documents, the presentation. So we didn't discuss the way forward because I thought as well we will be moving with the program. Hence, I'm saying for now I'll have to get the details. What is happening? What is the plan of action and that?
On a point of order, Chair. Point of order.
Honorable Klape and Nodada.
Chair.
Thank you, Chair. Chair, the reason why I said we must stop here and you retreat with your team, legal team, and the public protector was for the very same fact, let's not ventilate all this here and like we are cross-examining the public protector now. Let's allow you to go and find out all these issues from her. Tomorrow morning, you would have arranged everything that needed to be arranged and have more information for us as committee members. So I still stand with the fact that let's stop here as members of committee, as we have indicated, and allow you to go and find out everything, then let's receive that report tomorrow as the meeting is continuing tomorrow. Thanks.
No data. Thank you, Honorable Klape.
Chairperson, I think it's very important for us to, you must be able to take the clarities from members of this committee in whatever form it comes from, because we individually need to get an understanding as to what is going on. Now, from my understanding, from what the public protector has responded and said to us, is one, she did not know that the legal counsel, and I obviously want to best understand this so that we know how to deal with this moving forward. She did not know whether her legal counsel or not would, leave her at this point, and she doesn't know whether or not she will still be utilizing the same legal counsel. And therefore, she's requesting two things. One, either to engage her current legal counsel that she says to us she did not know was going to leave what she terms now, quote unquote, illegal process. And then the second thing is to say, well, if they don't agree, then I'll have to go and find, a legal team that needs to be briefed and so on and so on and so on. Now, Chair, I hear what others are saying in terms of, engage the public protector and so on. She just indicated to all of us now that she doesn't understand what she'll be engaging with you and the evidence leaders without her legal team with her. So I think it's important for us, Chair, to understand what is going on as a committee and set a decision or a resolution of the committee as to what must happen moving forward. Because the public protector has a right to have legal representation, and we must give a specified timeline as to when that can be sorted out, so that we continue with the program that has been resolved by this committee to continue with. And I think it's important to understand those clarities. There mustn't be members that are curtailed to ask questions, as Honorable Sukeras has tried to ask her own questions, so that we have a full understanding as all the stakeholders that are involved in this process, so that we know how to advise to proceed, even to you as a chairperson. Thank you so much.
Okay, let's round it off now, members, so that I can wrap up the meeting. Honorable Malema and Ngosi.
Thank you, Chair. No. I don't know why you allow the evidence leader to do what she's doing. Because at the point where we are, she has got no role. There's no any evidence that is being led now. We are having a discussion as members of parliament on how we're going to proceed. Now you leave here to ask public protector the questions, Chair. Please protect the public protector. Her legal team is not there. Don't engage in unconstitutional things. Where does she get the right to ask public protector questions? We're doing exactly that. We are trying to find a way out of this situation. And then she asks a public protector a question as if we're leading any evidence. Her role is to lead evidence, and no evidence is being led here. She must respect us.
Thank you, Honorable Malema. Ngosi, you're the last one. Oh, Judith.
Yeah, no, Chair, I think perhaps what we should do is, if members feel we should have a discussion on this issue, one, that we should excuse both the evidence leaders and the public protector and continue with the meeting to discuss the next steps on our side as an oversight committee. In other words, what steps are we going to take to address this issue? But that will depend on your summary, because I think every time you summarize, we come back, etc., and it creates a problem. Perhaps just to follow your precedents for today, excuse them, and then discuss the way forward with yourselves and take forward the suggestions that may have been made. Chair.
You clearly are not in a mood to allow us to prepare even for that. Nemadzinga?
Ndoribuwa Chairperson, like when I said, when you concluded and we kind of were agreeing with yourself with the adjournment of today proceedings. However, the issue that we are then as MPs, we've taken a decision to proceed with the proceedings. That's the first thing. Now, the second part comes in that it hampers now on our proceedings that which has happened currently. Therefore, it means that then you need to give yourself time to be able to deal with that which you need as part of your proceedings. Now, public protector is not in a position clearly because you don't want to prejudice her from a legal representation as a right. She just said to us that she has to consult with her counsel and lawyers so that she can understand. But clearly then means that she needs to be in a position perhaps to respond to the committee. And my suggestion will be that we still go back to what we agreed when Honorable Tlampe made the submission to adjourn, but secondly, Chair, to allow her the opportunity to be able to deal with that process of herself with the legal team. And perhaps what you can say, then she can also be able to confer with the committee section when she is ready. However, as we said, there's issues of timelines. That the rules empowers you to be in a position to get the timelines that is reasonable for that process to happen. And I think that's where we are, Chair, because if we were to want to deliver this issue, I'm afraid that we might find and put ourselves in a situation where we don't want to find ourselves. But I think the Chair is correct in your posture and what you said. However, the only thing that you are taking out is to have the backroom discussion. Perhaps that is something that we're saying, Chair, your consideration on the backroom, also on the issue of the meeting proceeding tomorrow, Honorable Deputy Chief Whip, that it might not be at this point. So we will leave that administrative matters to yourself, Chairperson, to ensure that you adhere to the rules. You give us within reasonable time the date where we're going to resume, because it doesn't take away from the decision. We're still resuming with the process. However, you give the public protector a chance to be able to do that. So the rest of the administrative, we need to leave them to you in terms of time frame. When are you calling us back? Where the matter between yourself or your committee and the public protector would have been dealt with, so that we can continue with the cross-examination. The colleagues who are coming tomorrow, they need to be communicated on time in terms of the suspension. Not suspension is not a good word, but the pause of the process. It's a pausing. Thank you, Chair.
Thank you, members. I think, members, what would help is that let's go back to this point that retreat for tonight. The time that is set for a meeting tomorrow is still that time, whatever nature of that meeting, because it would help that we go to that meeting with matters much better clarified than wanting to continue now with us not doing any kind of groundwork. It really would not assist. So I think you just need to take a step back and retreat, and we'll continue to do our work, and so we'll indicate. So for tomorrow, in terms of the meeting, you would come back and give also us a proper direction, but we're going to do the work to clarify a number of things that can't be clarified in a meeting like this. I don't think it really would work, no matter how strong we feel about getting this particular answer and that answer. It's not going to work. And I think the reality is pointing to that. So we have tonight to just rethink about how we proceed tomorrow. But I want you to leave here knowing that the meeting has not been changed for tomorrow. Can we leave it at that, colleagues?
Yeah, thanks, Chairperson. Thank you.
Thank you, honorable members on the virtual platform. The meeting is adjourned for now. I'll see you
Yes.
tomorrow.
Long live the chairperson.
Thank you,
Recording stopped.
Yebo.